cases, I think they're default.
So
I don't see them here.
Did we do Daniel Ragland?
No, that one will be a dismissal. I think they're default. I don't see them here. They were here, but I told him he could leave if he trusted me to enter a dismissal.
Okay.
That one will.
All right. Let's see. Let's call that one. And then okay. Calling case number 233475551, Marwood, Marston 2020 versus Daniel Ragland.
Dana Hull, P77966 on behalf of the plaintiff.
Morning, Ms. Hull. Question is this matter dismissed without prejudice?
Yes, we are moving to dismiss because he paid.
All right. Matter is dismissed without prejudice. Right. And is Kawana Hayes here? Kawana Hayes. I don't see Kawana Hayes in the breakout room. If anyone is on the phone, please hit *6. Calling case number 233475553, Trumbull Crossing, Detroit versus Kawana Hayes.
Dana Hull, P77966 on behalf of the plaintiff.
Thank you. Ms. Hayes. Is there anyone on 1229 Elijah McCoy Drive? All right, Council.
Your Honor, at this time, Ms. Hayes owes past due rent of $6,838, as well as costs of $160, for a total of $6,998.
All right, that amount is to be paid. So this is a non-payment of rent. Defendant failed to appear. Default judgment is entered in favor of the plaintiff. Defendant must pay $6,998 by June 12th. June 9th. 2023, or a writ of eviction can issue. Calling case number 233475554, Lexington Village versus Marva Benson and all occupants.
Dana Hull, P77966 on behalf of the plaintiff.
Counsel. Marva Benson here. Does anyone reside at 1310 Pallister? Counsel,
Your Honor, this is a termination of tenancy matter, so we are just asking for judgment for possession, giving Ms. Benson until June 9th to move.
all right. Defendant failed to appear. It's the termination of the tenancy case. Default judgment is granted in favor of the plaintiff, where defendant must vacate by June 9th, 2023, or a writ of eviction can be applied for. 554. Calling case number 233475555. This is Marwood Marston versus Devon Porteez, Savannah Snipes, and all occupants.
Dana Hull, P77966 on behalf of the plaintiff.
Thank you. Does anyone live at 53 East Marston Street? Anybody on East Marston? Okay, I don't see anyone here in the breakout room by that name. Counsel, are you requesting a default judgment?
Yes, we are.
All right, this is a complaint for non-payment of rent. How much rent is owed right now?
Okay. What was the last name again, Your Honor? Oops.
Corti, Porties.
Yes, I found it. It's $5,998.81 is the past due rent. And then the costs are $160 for a total of $6,158.81.
All right, that must be paid by June 9th, 2023, or a writ of eviction may issue after that date. Calling case number 2334-7556, Trumbull Crossing, Detroit versus Stephanie Tyus.
Dana Hall, P77966 on behalf of the plaintiff.
All right, is Stephanie Tyus here? Stephanie Tyus. Does anyone live on at 5500 Trumbull on the 10th floor? All right. Counsel.
Your Honor, at this time, Ms. Tyus owes past due rent of $3,637.02, as well as costs of $160 for a total of $3,797.02.
All right, at that amount, a default judgment is being entered because defendant failed to appear. She must pay $3,797.02 by June 9th, or a writ of eviction may issue thereafter.
Yeah, I will send those in. That's all I have.
All right, well, congratulations for making it out of here before 10:30, and
Yeah.
have a great day.
You too, thank you.
You're welcome. All right, and
No, I can't.
Attorney Moore, are you here?
Yes, Your Honor, I am still here.
Okay, legal aid passed over the number for their office. I just gave it to the court officer to give to the defendant, your defendant, so it may be a few minutes until we can call your case. So,
Okay, well, thank you. I brought my patients today, so thank you. I appreciate you.
fantastic. You're welcome. Great. Chris Clayton, Adam Alexander, you have your hand up. You've had it up for a while. What's going on?
I was just wondering on any information on case number 2334788.
4738.
47588.
Now, is Richard Flinner here?
I haven't seen them.
Richard Flinner. We'll call this case shortly. Mr. Flinner, are you expecting a dismissal?
We came to an agreement, so I was under the assumption that he was just gonna dismiss this.
All right, let's see what's going on. Not here, so. Calling case number 2334758, Richard Flinner versus Cody Mick. And is it Adam Alexander?
It's Alexander. They spelled it wrong.
Okay. You at 16644 Lenore? I do have a number for Mr. Flinner. I'll ask my clerk to give him a call, and then if he said he's not appearing, I'll dismiss the case. All right.
All right.
And then, so sit tight. You can keep your hand up if you want. Mr.
Okay.
Cashmore and Mr. Dad.
Morning, Your Honor. Here on case ending in 6943. We're just going to ask the court for a 2-week adjournment, if that's okay.
Okay. We'll be out of the digital era in 2 weeks. Just so you know, we're going back in person. So
We just need some information back from Detroit Metro as far as a payment that was made to the prior property manager. So they're saying about 7 to 10 business days. So that should give us enough time.
is June 13th good?
Yes.
Yeah, well, hold on, Your Honor. I'm sorry.
Morning.
And Attorney Lori Waddle's appearing here on behalf of the defendant.
Pardon me, call it. Calling case number 2346943 Golden Key Real Estate versus Deshaun 80.
Morning, Your Honor. Joshua Cashmore on behalf of the plaintiff.
And may it please the court, Your Honor, Lori Waddle's appearing here on behalf of the defendant, Ms. Easley.
How do you pronounce your last name?
Deshaun Easley.
Okay. All right, thank you, Ms. Easley. All right, you need 2 weeks. It's June 13th, 2023 work for everybody.
Yes, that works for me.
That works for me as well, Your Honor.
All right, let's do it let's schedule it for 9:30 a.m. on the 13th and see you all back. Remember, this is in person, so.
Thank you, Judge.
All right, thank you, Your Honor.
You're welcome. Y'all take care.
You as well.
Thank you. 943. Mr. Dad.
Yes, Judge, could we call case ending in 5955 to see if the tenant is here?
Keisha Johnson here. Keisha Johnson. Did you see her in the breakout room? I don't
I
see
do
her.
not.
Breakout room's gotten a little empty. Keisha Johnson is Jasmine Richards here.
Yes, good morning, Your Honor.
Yes, I'm here. Can you hear me? I'm not sure.
Yes,
I
we can
can
hear you,
hear-
Ms. Richards.
Okay.
And you're represented by Attorney. Good morning.
Yes, that's me, Your Honor, Lauren Namazi at Michigan Legal Services. I think Diane Wyrock, Attorney Wyrock, is ready.
Yes, I am, Your Honor.
All right, good morning, Ms. Wyrock.
Good morning.
All right, calling case number 2334-4056, Elmwood Properties versus Jasmine Richards and all occupants.
Diane Wyrock on behalf of plaintiff P 59773.
Good morning, Your Honor, Lauren Namazi, P85424, Michigan Legal Services, on behalf of Jasmine Richards, who's present in the Zoom gallery.
Right. Okay, we're parties able to work something out. Ms. Richards, can you state your name for the record?
Jasmine Richards.
Thank you. Richards. All right, have parties come to an agreement?
Yes, we have. Ms. Nabazi, you may put it on the record.
Yes, the parties have reached a consent judgment of possession after land contract forfeiture. The amount due under paragraph 3 is $5,450. Other damages for property taxes of $1,267.84. Cost of $225 for a total of $6,942.84. More than 50% of the purchase price has been paid, so it is a 6-month redemption period. And then clarifying or including under paragraph 7B that additional breach to cure is to pay the water bill owed to Detroit Water and Sewerage, currently $14,286.77. And under paragraph 9, that if defendant provides proof of payments made but not accounted for in the ledger, then plaintiff shall give credit for those payments and subtract them from the judgment amount due under paragraph 3.
All right, what was 7B? What did 7B say?
Cure the additional breach of the water bill, currently $14,286.77.
All right, and what was said after that?
Under paragraph 9, further orders, if there's any proof of payment provided by defendant that were made but not accounted for in the ledger, then those payments shall be given credit for and subtracted from the amount due under paragraph 3.
Okay. All right, Ms. Richards, do you understand this agreement?
Yes.
All right, and do you give Ms. Namazi permission to sign your name on this agreement?
Yes.
All right, the court is satisfied. Good luck, Ms. Richards. Mr.
Thank
Attorney
you.
Wyrock, did we miss anything?
No, you did not. And Ms. Nabazi, you have my permission to sign my name and submit it today.
Okay, I will do that.
Thank you.
All right, thank you all. Have a great day.
Thank you. You as well.
Thank you.
Keisha Johnson. Keisha Johnson. Sylvester and Quentin Brown.
Here, Your Honor.
Yes.
This is Sylvester speaking.
All right, have you checked in? Is Quentin Brown here? Is Quentin Brown here?
For which case number?
Hello?
Hello.
Hi.
Hello, yeah, you all, please don't talk to each other. Are you Richard Flinner?
Yes, sir.
All right, good morning.
Good morning,
Hi.
sir.
Chris Clayton's here as well as Adam Alexander. Are you all ready? Do you all have a resolution in your matter?
Have we what?
Have
Reserve?
you worked out some type of resolution or agreement?
At this time, Chris has worked out a payment plan and he's been paying on schedule as we discussed. And at this time, we have worked out that resolution. Long as he continues making, the payments, we are fine.
All right, so are you requesting to dismiss this case? Or,
At this time, yes, sir.
okay, all right, because I can either dismiss it or enter a conditional dismissal consistent with the terms. But it's totally up to you. If you're asking for a dismissal, I could dismiss it.
At this time, I'd like to, can we dismiss it with terms?
What are the terms? Let's call this case. Calling case number 233475888, Richard Flinner versus Cody Mick and all occupants on Lenore. And can you state your name for the record?
Richard Flunner.
Thank you. And is it Chris Clayton up there?
Yeah, Chris Clayton.
All right. What were your terms of the agreement? If you don't mind putting them on the record.
They fell behind on rent and Chris agreed to continue to, make payments every week of a few $100s to catch himself back up because they fell like 2 months behind at $750 a month. And right now Chris is paid $900 in arrears, and they have at this time $600 more to catch up.
That is what I have as well. So when will you have this $600, Mr. Clayton? When can you pay this $600? Or when have you all agreed to have this $600 paid?
I can pay. Hold on. No, it was freaking. So I can pay this Thursday, Friday. Most likely 600.
Ultimately, I mean, as it stands right now, worst case scenario, you will have until June 9th. Now you all have an, so I'm going to, all right. Thing is, Mr. Flinner, you're going to have to submit this to the court. You will have to submit this to the court. But is there any objection? Is there any objection to removing the named parties and we enter this as an all occupants judgment? We either do a conditional dismissal with these terms of $600 to be paid and however much time you want to give them.
All right.
Is that?
Yeah.
Is that okay?
That's fine.
All right, so we'll do a conditional dismissal. We'll keep it in named parties, but $600 must be paid by
June 9th.
what date are you agreeing to?
June 9th.
June 9th, Mr. Clayton?
This coming Friday?
No, it's next Friday. So you should.
Then yeah.
Okay, by June 9th. And based on the conditional dismissal, there's a conditional dismissal form. And I'm going to invite you all into a breakout room with legal aid after this.
Okay.
Because you have a resolution, you all can work that out, but I want to make sure you send in the proper documentation to the court. I didn't want to dismiss this case when everything wasn't paid, and I want you all to have a clear agreement. But I can't provide legal advice, and you don't have an attorney. If you are comfortable drafting a conditional dismissal, then you don't have to go to legal aid. But if you're uncomfortable or you don't know where to find it, then a quick conversation might suit you all, well, but it's up to you.
I just
Mr.
have to go down to the court to the third floor, correct?
Second floor.
Second floor. Okay. Yeah, I know where to do it.
Okay, all right, so do you, Mr. Clayton, do you give Mr. Flinner permission to sign your name on the conditional dismissal?
Yes.
All right, so the terms are $600 by June 9th.
Okay, I agree.
And there's a box for 4A or 4B. 4B allows for an automatic judgment and writ of eviction to enter. 4A allows for more time and notice before a judgment is entered. Which route do you want to go, Mr. Flinner?
I would like to, court A.
Okay, 4A,
Yeah.
4A. So you'll mark that on the box, but I just wanted to be clear before you signed it because you're giving Mr. Clayton notice. So if you can take a picture of it and text it to him before you submit it to the court, it may just, as a practical matter, be helpful and everybody's on the same page. But
Okay, appreciate
these are the
that.
terms. All right, you all, good luck. Make sure you submit that to the court, Mr. Flinner. I'll enter a conditional dismissal in the computer. This is the 4A conditional dismissal for $600 to be paid by June 9th.
Okay, thank you.
You're welcome. You all have a great day.
You too.
Okay, now you all are free to leave unless you need to talk. In the breakout room, feel free to vacate. Enjoy your day.
Thanks, you too.
All right. Yeah, iPhone, ma'am, with your hand up.
Hi, Judge Sabree, this is Keisha Johnson.
Keisha Johnson. Are you on
Yeah.
the case with Alfonso Johnson?
No, I was on the docket with by myself with Continental for Jefferson Square. I had a 10 o'clock court hearing, but Chrysler didn't want to release me for work, and so I pretty much had walked up, and they were saying that only what I need something in writing from you stating that I had court today in order to keep my job, because my other phones are cut off, so I'm using my neighbor phone.
All
to come
right,
to
well,
court.
Mr. Dodd,
Huh?
I'm trying to get attention to the attorney in your case.
Okay.
I spoke to Ms. Johnson and Ms. Haddad to resolve this matter. So I'll place Ms. Johnson in a breakout room and see if we can resolve this.
Okay, thank you.
You're welcome. And then let me know what you need, Ms. Johnson, and we'll figure out how to get to your
Okay,
employee.
I just need something in verification with my information and your name stating that I did have court today. And I can come down there and pick it up on the security or wherever you can leave it.
Okay, what time will you
That
be
way
able
I
to get
can keep my job so I can try to pay these bills, Your Honor.
Yeah, we want you to keep your job, Ms. Johnson.
Yeah, it's hard to get in Chrysler now, so I need that.
All right, well, just make sure we get it to you. Don't let us forget.
Oh, I'm not. That's on you. I can get going to work tomorrow. If not, I'll be fired. So I'm definitely getting the paper today. Thank you.
Okay, you're welcome.
Okay.
I'm gonna call a few more names.
Okay.
And you may see an invite to a breakout room, Ms. Johnson. Click it if you see it.
Okay, I haven't seen one yet, but I will.
All right, and Mr. Spaniolo,
Good morning, Your Honor.
good morning. All right, I'm gonna call your address, and then I'm going to call Attorney Maxim Cole's docket. You only have one here, so let's call your address. What is the address, actually?
10917 Roxbury Street.
Does anyone live at 1097 Roxbury?
And I believe
Yes.
Attorney,
My uncle and I are here. Can
I
you hear
believe
us?
it's.
Yeah, we can hear you.
I had to come to his job because he couldn't get on his phone. So we at his job.
How you doing, sir?
Doing well, how are you?
Okay.
All right, do you all have counsel, or would you like to speak to the landlord's attorney?
Your Honor, I think the last time Connor Brown was. and I
Yeah,
seen
Connor
him
Brown, he said he had 2 cases. So I guess I texted him and told him that you all were on. He told me to text him.
All right, what were you saying? What were you saying, counsel?
Mr. Brown is here, Your Honor. I see him on the screen.
Yeah,
Okay, you all need to talk.
yeah, I think we need to do an intake for Mr. Pickett. So,
How you doing?
They're gonna probably put it in.
good morning, sir. I'll put him in a breakout room and we can, we can talk.
Okay. And I'll recall it, counsel.
Thank you, Judge. And if there's a legal assistant available who could help me out with that, appreciate it. Put him in room 4.
1 second, join. Press it. It's on the screen.
Oh, room 10, I guess.
That's the lawyer.
Are we supposed to be saying something?
Well, he about to come in the breakout room. He ain't put you in the breakout room.
Okay.
It's gonna pop up on the screen.
Is Tiffany Snell here? Tiffany Snell. Is Monique Peterson here? Is Davita Reed here? Is David Brooks here? Is Cortez Strawder here? Is Will Brown here? Just the right, I see you are here. Good morning.
Morning.
All right, do you have an attorney? Would you like to speak directly to the landlord's attorney? Yeah, Mr. Wright. Yes, sir.
I was, if I could, I would speak to the landlord's lawyer.
Okay.
It is tripping. I'm dealing with
We're
the
gonna
one
put you in a
situation
breakout
with
room. No.
Sharnita Williams. She came up here talking about she ready to get her paperwork to get these people out of her house. It's Stephanie Tyrus. I know we're going through.
Your Honor, I apologize for interruption, but I'm dismissing the Chester Wright matter, so I don't know if we need to speak. And I'm also dismissing Cortez Strather case.
Okay, so 468 and 470.
Correct.
All right, let's. Mr. Wright, let's call your right now and get you out of here. Continue taking your brains out. Calling case number 2334740 ID Capital LLC versus Chester Wright.
Yes.
Good morning, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff.
All right, Mr. Wright, can you state your name for the record?
Last name Wright, first name Chester.
All right. Counsel, are you requesting a dismissal without prejudice?
That's correct, Your Honor.
All right, this matter is dismissed without prejudice. You are free to leave. Mr. Wright, you'll receive a dismissal in the mail.
Will I be still able to talk to the landlord's lawyer?
That's him right there.
Call the default.
You all have we have a question for him? Ask him right now.
Okay. It's not, I guess, the question, Anna. My question is how come when I sent them my payments and they would put it in the system late, charging me a late fee? Which is how we got here today.
Okay. Do you want him to address the late fees or just you want his contact information or something, and maybe you all can discuss this afterwards?
Yeah.
Your Honor, I'll just direct Mr. Wright to contact the management. I don't deal with billing or entering any payments in, so I would have no way of answering his question.
Okay.
Well, that's how. I mean, that I can never seem to get in contact with management, and this is how we got here because I was always paying on time, and apparently they botched my payments.
I will notify the management to look into this issue, okay?
I appreciate it.
And then Mr. Wright, just keep trying to contact management.
Had to.
Yeah, keep trying, keep whatever effort you're using, just continue to do that as well. And I'm sure Mr. Mexico will get in touch with them, but put your best foot forward so you don't have this issue again. And keep your documents and keep your receipts, for sure. But you are free to leave, Mr. Wright. And
You too, thank you.
You're welcome. Calling case number 2334740 ID Capital LLC versus Cortez Strather and all occupants.
Good morning, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff. Your Honor, plaintiffs moves to dismiss this action without prejudice.
This matter is hereby dismissed without prejudice. All right. Let's see who else is here. Is Alfonso Johnson here? Alfonso Johnson. Nataran Ward. Nataran Ward.
Nataran, I'm here. Good morning.
Good morning. And Ms. Ward, do you have an attorney?
I'm sorry.
Are you represented by an attorney?
No.
Okay. And you want to speak directly to the landlord's attorney?
Yes.
All right. Ms. Ward, I'll get you in the breakout room with Mr. Max Cole, and hopefully you all can work something out.
He got it. Sorry. 18 sitting on the seats. And
What room is that? Did it say room 6? Yeah, room 6. And is Cheryl Foster here?
yes.
All right.
Yes.
And Ms. Foster, do you have an attorney?
No, can I have counsel?
I'll invite you into a breakout room and someone should talk to you.
Okay, thank you.
Mr. Harker, how can we assist you?
Okay.
Resolution on 507, Your Honor.
This is where she got. I'm here. I love
Motorola with the glasses, you have to cut off, you have too many devices on. We're getting feedback. Calling case number 2334-7507. This is Go-To Guy Property Management versus Miami Logwood.
Good morning, Joe Horka, P75969, if you have the plaintiff.
I'm Miss Lockwood. I'm here.
All right, and counsel, would you like to put the terms on the record?
She got pay or vacate.
Yes, Your Honor, the parties would like to do a conditional dismissal with box 4B checked. Total due, including June and July's rent, will be $4,267. She's gonna pay her June rent by June 5th, her July rent by July 5th, and the remaining balance by July 15th.
By July 15th. All right, so I'm gonna ask you, Ms. Logwood, what's your rent?
Excuse me.
How much is your monthly rent?
Well, at this moment, it will be $1,300, and Section 8 will pay the whole portion of $1,300. And I would have to just pay my back rent.
Okay. So
And
how
as
much
of now, it's $754.
The 754 is what, counsel?
As of now, her monthly rent stands at $754.
Okay, and arrears? Okay, all right, so do you have any questions, Mr. Logwood?
No.
All right, and did I miss, do you give Mr. Porter consent to sign your name on a conditional dismissal?
Yes.
All right, and you said 4B is checked, correct? With 4B being checked, that means, Ms. Longwood, that if you fail to fulfill this agreement, that a judgment and a writ of eviction can issue at the same time without going to court. You understand?
Yes.
So we'll be at we're headed to the finish line. We won't have to come back to court either way. Either this case is dismissed because page 4267, or a judgment and a writ of eviction could be entered if if the June 5th, July 5th, or remaining balance isn't paid. So, good luck. Do you give Mr. Horka consent to sign your name on the judgment?
Yes.
All right, the court is satisfied. Keep an eye out for a copy. It may take a week or two, but, Mr. Horka, did I miss anything?
No, Your Honor.
Thank you. We're done, Ms. Logwood.
Thank you.
Are you ready on Hernandez, Ms. Horka?
Yes, I.
Okay. Calling case number 2334-7501-532 Tidal Way LLC versus Ariana Hernandez.
Morning, Joe Horka, P75969 to the F the plaintiff.
Good morning. Ms. Hernandez, can you state your name for the record?
Ariana Hernandez.
Thank you. Parties work something out?
And the parties would like to do a conditional dismissal, box 4B as follows. Total due, including court costs, is $2,005.95. Mr. Hernandez made a payment on Friday of $1,725. It just hasn't hit the client's ledger as a result of the holiday weekend. She'll pay the remaining balance of $280.95 on or before June the 9th.
All right, so we're pretty much at the finish line here.
Yes.
Looks like 200595. You've made a significant payment of $1725 down to probably what amounts to court costs. But that isn't cost by any means. So 281 by June 9th. Make sure you get that paid. In this case, it'll be dismissed. If you don't, a judgment and writ to enter for that amount. So just try to take care of that by June 9th, and this matter be dismissed.
I appreciate it.
Okay, thank you.
And 4B means we don't have to go back to court. I probably said it 10 times already, but this is your case, so I'm telling it to you too. A judgment and a writ of eviction can enter at the same time if you don't follow through with the agreement. So make sure you just take care of that 281 by June 9th. In this case, be dismissed.
Okay.
All right, good luck.
Thank you.
Sure. All right, thanks. Moto G5G. Start with their hand up. Who placed their hand up in the chat? Who have feedback on their computer? I'll call you next, Mr. Mexico. I just want to see what's going on. Make sure. Yes, sir. All right. All right, Mr. Mexico, what do you have?
Your Honor, we're ready on 7474.
Calling case number 2334-7474. This is ID Capital LLC versus Nataran Ward and all I.
Good morning, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff.
And Nataran Ward.
Good morning. Nataran Ward.
Good morning. All right. Mr. Mexico, can you place the terms on the record?
Yes, Your Honor. Would like to propose to the court a judgment by hearing against any and all occupants. Rent to retain $900, cost of $160, totaling $1,060 to be paid by June 9th. Again, this is against any and all occupants, and I'll dismiss the named defendant from the judgment.
All right. because this is an all occupants judgment, we're gonna enter this as a judgment by hearing versus a consent judgment, where $10,060, 1060 must be paid by June 9th, 2023. If that amount is paid by June 9th, then the judgment is satisfied. If that amount isn't paid by June 9th, then an application for a writ of eviction can be applied for. So they can apply for a writ on June 12th, would be the earliest date, and that would be against all occupants. So 1060 gets over to the landlord before June 9th. This amount is satisfied. If not, a writ of eviction can enter into the name of all occupants, where all occupants must vacate. Ms. Ward, do you have any questions?
No.
All right, good luck, and keep an eye out for something in the mail over the next 2 weeks.
Okay, thank you.
You're welcome. Good luck. I think Cheryl Foster checked in, but we can call some defaults in the meantime. And I have someone in person, so let me address them and then I'll start calling your defaults.
Thank you.
You're welcome. Calling case number 23347567. This is Armin Templeton versus Sharnita Williams.
Yes.
And
Present, Your Honor.
thank you, Counselor. And we have Ms. Williams here as well. Please state your name for the record.
My name, Sharnita Williams.
All right, and we were able to, Ms. Williams was able to speak to someone from Lakeshore Legal Aid. There are some technical issues. Ms. Williams is in person and no one else is in person. And there are some communication issues with being able to transmit documents back and forth. So the defendant through their counsel is asking for at least a week adjournment. Do you have any response, Ms. Moore, or are you in agreement with that adjournment?
Yes, good morning again, Your Honor. If I may, please the court, Fallon Moore, P84281 on behalf of plaintiff Mr. Armand Templeton. Your Honor, this is a complaint to recover possession, Your Honor. Tenant was successfully served. And at this point, we've actually been trying to reach out to the tenant since January of this year. So, there have been several notices mailed to the tenant. Some were sent just regular first class mail, others sent certified mail. And so there's been, definitely lots of communication sent to the tenant. I'm not for sure what she's trying to provide at this point, Your Honor, but, my client does have a right to his property back. And that is what he is seeking today. So I'm not for sure what exactly she's trying to send over, what sort of documents, but none of the documents will defeat the fact that my client is the owner of the property and is simply looking to obtain possession of his property back. Ms. Williams never had a lease agreement as far as with my client. And so, at this point, I'm not sure what she's trying to send, but Your Honor, it is our position that none of the documents will defeat what my client is asking for, which is possession of his property.
Understood. Is it Mr. Keenan, are you representing,
Yes, I spoke with Miss Williams. She does not have a cell phone or an email, so I'm unable to even get a retainer electronically to formally enter in this case. She is coming right to my office from court today, so I can look into this case. With the technical difficulties, I couldn't even give her advice. So I have asked her to ask for a short adjournment just so I can look at the case a little bit more and see if we can represent her. There's very little I can do without a virtual connection to enter.
Understood. Well, with that, Your Honor, and I'm sorry if I may, with that, Your Honor, I mean, it's understood if we can do a very short adjournment. I do understand, the technical difficulty. So if we can do a very short adjournment, I am in agreement to that.
Yeah, even if it's a week, we're fine.
Yeah, I think it's as a practical matter. And then in the meantime, once you're able to retain her, or once she retains you, then maybe documents can be sent over, and if there's an argument, there's an argument. If not, then maybe it's just a resolution at that point. So yeah, next week, based on what's been presented, it seems like we'll have a resolution. So what day is really the question. We're back in person next week.
Yeah, we'll all be there together. So whatever the court can allow. I provided my office address to Mr. Nevels to give to Ms. Williams, and she said she'll be on her way today to meet with me.
Attorney Moore, does June 6th work for you?
Yes, Your Honor, that's perfect. Thank you.
Okay. Lakeshore is here on Tuesdays and Fridays, so I try to accommodate their schedule as much as possible. Okay, let's do 9 a.m. And if you all have something before or after, I'll just accommodate. I'll be here. So.
Okay. Thank you so much. I appreciate it, Your Honor. Have a great one.
Yes, and Attorney Moore, if you could send me a chat with your contact information, that might keep the communication going. I lost my breakout room privileges when I left for the phone call, so.
Understood. I'll send it over to you now, counsel. Thank you.
Thank you much.
All right, thanks, Clark.
Thank you.
And Ms. Williams, I wasn't ignoring you, but we might as well keep all the arguments.
Okay, and I understand that because when she said, I received certified slips, but far as anything concerning what's going on legally with that house, no, that's what I'm going to speak to the attorney about. Because can they hear me?
Everybody can hear you.
Oh, because I was getting ready to say something. Okay, so.
Yeah, that's why. Open forum right here.
Oh, okay.
We'll talk to your attorney and then.
Yeah, okay.
And I'll see you back next week.
Okay, absolutely.
All right, thank you.
Uh-huh.
Mr. Maxon Cole.
Yes, Your Honor, ready.
All right, and I have one issue. This Moto 5G, I don't know who he is. And it's a lot of feedback going in that. So I'm going to unmute him just to make sure he's not one of your defendants that we're about to issue a default judgment on. So everyone be patient. Turn your volume down if you have to, but I have to do this. Excuse me, sir. Can you hear me? Sir, can you state your name?
Augustus Horn.
Augustus what?
Augustus Horn.
Okay, and Mr. Horn, what's your case number?
233-44-616.
Okay, Mr. Horn, let me check your case number for you and see where you're supposed to be, because I remember you giving this to me earlier. Sorry about that, I forgot that that was you who gave me that case number. And then I'll call your cases, Mr. Mexico. All right, so Mr. You're early a day. You're here tomorrow at 9:01, but you are in the right courtroom. Just sorry to have you waiting today. At least you have a preview of what's gonna happen tomorrow procedurally, but you're scheduled for tomorrow, same place, 9 a.m.
Yes, Judge.
Yep, 9 a.m. So I'll see you back tomorrow.
Okay. Thank you, Judge.
All right, let's start with Tiffany Snell. Calling case number 2334-7464. This is Country House, Detroit versus Tiffany Snell.
Good morning, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff.
Does anyone live on Woodbine Street in apartment 25? All right, counsel, you may proceed.
Your Honor, I would ask that a default judgment be entered at this time. I believe the move out date is 6/9, if I'm not mistaken.
You are not mistaken. It's a complaint to recover possession of property, termination of tenancy. Defendant failed to appear not once but twice. And the defendants must vacate by June 9th, 2023, or writ of eviction may issue. Did you have anything ready, or was it all deep?
Your Honor, I have no knowledge whether or not anyone is here, if anyone is represented, so
No
I leave
problem.
it to the court's discretion.
Is Monique Peterson here? And Ms. Johnson? No.
Yes, sir.
We have a letter for you, by the way.
Thank you very much. Where can I pick up that information from?
You give us an email, we can send it to you. Mr. Dad, are you ready on her case?
Ready, Judge.
All right, let's get you up there. And then Mr. Maximkov, you're back on deck. You're on. I'll keep calling your cases right after. Let's see.
Yes, sir.
Calling case number 2334-59 Jefferson Square Apartments versus Keisha Johnson.
Good morning, Your Honor. For the record, Ronnie Haddad, P 84927 on behalf of the plaintiff.
Good morning, Your Honor. Phyllis Wood, P 74800 on behalf of Ms. Johnson.
Good morning, Keisha Johnson.
Thank you, Ms. Johnson. All right, see, this matter has been adjourned twice. Have we reached the resolution?
We have, Your Honor. We've reached the resolution of the entry of a conditional dismissal in this matter. The total amount owing is currently $5,101.16, including court cost of $164. Ms. Johnson agrees to pay 12 monthly payments of $425.10 on or before the 15th of every month, starting on June 15th, in addition to the monthly rental payment of $335 on or before the 1st of every month. This will be a 4B, and 7 will also be checked in that a partial payment by defendant of the amount due of the $5,101.16 will not prevent an issuance of an order of eviction should a judgment enter after the default on this conditional dismissal.
All right, thank you, Ms. Wood, Attorney Wood, for that. Okay, do you understand the terms, Ms. Johnson?
Yes, sir.
All right, so your rent is still expected to be paid. That's $335 a month on or before the month. In the meantime, you have a balance of 510116. That's being split up into 12 monthly payments starting June 15th. June 15th, you 425.10, and you'll also pay that $335 per month. Now it's 425.10. Is her rent separate? Has her rent been kept separate from this agreement?
No, Your Honor,
Yes.
the 335 payable on or before the first of each month is the rental, is a monthly rental payment.
Okay, all right. Okay, the court is satisfied. 4B is checked, which means that a judgment or writ of eviction can enter at the same time, and as Attorney Wood stated, 7 is checked. So $5,000, they can still evict. $5,100, technically, they can still evict. Probably wouldn't, but by law, that box is checked. So it's important to just know. And for to answer this condition of dismissal, if you have any questions, make sure you ask your counsel, but thank you, parties, for getting this done.
Your Honor, I would just like for the record, Ms. Johnson, I have your permission to sign the conditional dismissal.
Yes, ma'am. And can you also let the judge aware that my email is implemented? So can I come into downtown to pick up the paperwork for my job?
Absolutely.
Okay.
Can we send it to, can you scan from right there?
Yep, Judge.
Attorney Wood, can you give us your email?
Yes.
Oh, you
But I
can't get
can't
it.
email her.
Yeah, okay. Well, we're here and we can leave it for you. I'm in courtroom 436.
Okay, I'll be there to get it. Thank you.
You're welcome.
Appreciate it. Court.
Ms.
What
Haddad,
time
I have your permission to sign.
Yes,
time are you
ma'am.
coming?
I'm on my way. I'm
Where
on my
you-
way there, Your Honor.
Where are you coming from?
From the Jefferson Square, from Kitchener and Jefferson.
Okay, so you'll be here. Yeah.
Okay.
All right.
Thank
Okay.
you.
You're welcome.
Thank you, Judge.
436. You're
Have a
welcome.
blessed day.
All right, you too.
Okay, bye.
Bye-bye. All right, back to you, Counsel Maxim Call. Is Monique Peterson here? Monique Peterson? Calling case number 2334-7465, ID Capital LLC versus Monique Peterson and occupants on Bentler.
Good morning, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff. Your Honor, I would ask that a default judgment be entered with a move-out date of 6/9.
All right, defendant failed to appear. Default judgment is granted. This is a termination of tenancy where Monique Peterson and all occupants must vacate by June 9th, 2023, or plaintiff through their attorney can apply for a writ of eviction. That's 465. Is Davita Reed here? Davita Reed. Calling case number 2334-7466, ID Capital LLC versus Davita Reed and all occupants.
Good morning, Your Honor. Andre Maximkov, P number 77075, appearing on behalf of plaintiff.
Thank you. Davita Reed. Anybody on Shiawassee? All right, counsel, it appears that Ms. Reed has failed to appear. Are they requesting a default judgment?
That's correct, Your Honor. I'll request a default judgment to be entered at this time. Rent to retain is $265, cost of $160, totaling $425. to be paid by 6/9.
All right. Defendant must pay $425 by June 9th, 2023. Or writ of eviction may issue. Defendant fails to appear, have a small balance, but default judgment is granted due to their failure. On case number 2334-7467. This is IG Capital LLC versus David Bruce and all occupants. David Brooks here. All right. Does anyone live at 19041 Bentler? Counsel.
Good morning, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff. Your Honor, I would ask that a default judgment be entered today for defendant's failure to appear. Rent to retain $610, cost of $160, totaling $770, to be paid by 6/9.
All right, default judgment is granted consistent with those terms. 770 to be paid by June 9th, 2023, or writ of eviction can be applied for. All right, is Will Brown here? Will Brown. Or anybody on West 7 Mile? This is a commercial property?
No, Your Honor.
Okay. Calling case number
Hello?
2. Yes.
For Will Brown?
Yes. Good morning.
Okay, good morning. I'm sorry. I don't know how this thing works, but I'm standing in for Will Brown because he's a witness on a case at Recorder's Court, and he had to be there. But the payment of $1060 will be paid in the morning to the real estate company or the agent.
All right, so let's do this.
Apologies. We can't hear.
All right, Attorney Mason.
Can you hear me now?
Your Honor, so here's what I propose. The balance I'm showing is 1,790 plus 160 cost. That puts us as 1,950. I'm willing to remove the defendant's name if the judgment is entered today by hearing and give him 10 days to pay it.
So it's not $1060?
It is not 1060, correct?
Okay, I know he has the 1060 as of today. Could I get time on the 950?
1950. 1060 was a balance as of April.
For $890 to bring him current? I mean, I'll get the 1060 paid in the morning, but could I get some time for the $890 to bring him current?
Your Honor, perhaps I can speak with the defendant in a breakout room so we don't have to take up court's time.
Okay, yeah, and then we'll keep it, it'll be private, and when you come out, just pop a hand up and I'll hear it, but it sounds like we're in striking distance on both sides, so not a problem.
Okay, now what do I do? Just
click accept or join, whatever the option is. Yeah.
And Your Honor, I didn't get moved. Oh, thank you. Thank you.
No problem. All right, Mr. Brown.
Yes, Your Honor.
I see you had your hand up.
Yeah, I was just wondering, when it will be my turn to, for the case to be heard.
Quentin Brown here.
I don't know.
Is that a relative?
Yes, my brother.
All right. Do you know if he's coming to court?
I don't know. Last I knew, when we had court, he had a public offender. I mean defender. So I'm not sure if that's still the case or not.
Is anybody representing Quentin Brown? Calling case number 23346527. This is Sylvester Brown versus Quentin Brown. May I have appearances? Can you state your name for the record, Mr. Sylvester Brown?
Sylvester Brown.
All right. And is Quentin Brown here? Does anyone reside at 8385 East Lance Street? And Mr. Brown, what is your relationship with 8385 East Lance?
That's my mother's house, and I'm her legal guardian.
Okay. And were you appointed guardian from the probate court?
Yes, I sent those documents to Quentin's attorney. I forget his name, but I emailed it to him back on May 15th.
Okay. And does Quentin have any interest in the property?
No.
Do you have any interest in the property?
I do. So my mother's, I'm her guardian, right? So she resides in a nursing facility. So it's my responsibility to pay the mortgage. I went to Quentin several times. He's not willing to help me pay the mortgage, so he can't stay.
Okay, but I just wanted to make sure that it's not as if your mother still owns the property, is that correct?
Yeah.
Okay, I just wanted to make sure it wasn't entitled to you and Quentin, and then you all really had a joint tenancy. So if you don't have, if your name's not on the title and Quentin's name is not on the title, and you have guardianship, I remember I wrote notes in my file that this is a guardianship case, and I remember it. This was adjourned from last week, correct?
May 15th.
Okay. It wasn't too long ago. Everything was Sabree is on the other side. But neither party is here, nor is there counsel here. So I'm going to grant you with a default judgment. I have everything that we need on here. However, this complaint is in your name. It really should be in, it's really not your property, it really should be in your mother's name. Are you requesting the court to amend the pleadings?
Yes, please.
Okay, I need to check something, Mr. Brown. I'll check something. I'm gonna pass your matter. We're gonna take a brief 10-minute break. We're almost done with the docket. I'll allow parties to discuss in the meantime, and then I'll call everything that's still pending, and we should be out of here. But I want to give my court reporter a 10-minute break. They're working remotely, so I'll recall this.
Okay, sir. Thank you, Your Honor.
You are.
So quick question. When you say recall, are you talking about today or a different day?
Oh, today. I'll recall it today. I check something because you'll notice Mr. Brown has your name on it. That's what I'm concerned about. The title of the property is in your mother's name.
Well, I have a
So,
management agreement too.
oh, you do?
I do.
Okay, all right. That changes everything. All right. Okay. Recall on case number 233465527. This is Sylvester Brown versus Quentin Brown. And can you restate your name for the record, Mr. Brown?
Sylvester Brown.
All right, and Mr. Brown, are you the guardian for the owner at 1587, for 8385 East Lance Street?
Yes.
And are you the property manager for that property?
Yes.
Okay, do you have a management agreement with your name on it?
Yes.
Okay. Court's been presented with guardianship documents from the Wayne County Probate Court as Mr. Brown as the guardian for his mother, and Mr. Quentin Brown has failed to appear. How much time are you willing to give Mr. Brown?
0.
All right, so you got to give him 10. So
okay.
Judgment. This is for termination of tenancy. Defendant must vacate by June 9th, or writ of eviction can enter that following Monday. You can apply for it June 12th. All right.
Thank you, Your Honor.
You're welcome. Make sure you submit that to the court. Even if you have to come down here, just get it to us and we'll process it.
Does the court have a, do you guys deal with email? Who do I email?
I can send it by email. And Mr. Maxim Cove, I'll call what you have and then we'll take a break.
All right. Your Honor, I have one that we can put on the record. It's the 7469.
Okay, and Mr. Brown, I'll get an email to you in I'll just put it in the chat.
Oh, she's.
Thank you, Your Honor.
Your Honor, Miss Brown, I think that's what her name is. She is not technologically savvy. She's still in the breakout room that's entitled Maxim Cove. If you could just pull her out, I couldn't explain to her how to exit out from the breakout room.
Okay. Yeah, I don't think she can because she doesn't have breakout privileges. So hold on one second. Sending this email. I think you can get her out of there, but I'm going to do it because you may not have to. Mr. Brown, did you see that in the chat?
Yes, Your Honor, I see it.
All right, and who's stuck in the room? Will Brown, Miss Brown, or Will Brown?
Correct, Your Honor.
All right, we'll get her out of there. All right, Mr. Brown, I'm gonna let you go. Make sure you get that. Well, I'm just gonna place you on mute, and then we'll keep an eye out for that.
Okay.
All right, Miss Brown, I see you are
Yes.
back. Welcome
Yes.
back.
Thank you.
You're welcome. All right. Were you all able to work something out with Mexico?
We have, Your Honor. Yep.
Okay. And what is that agreement?
Your Honor, would like to submit to the court a judgment by hearing against any and all occupants. I'll dismiss Mr. Brown's name of the judgment and rent to retain as 1,790 plus 160 costs, totaling 1,950 to be paid by the 16th of June.
Yes.
Okay. paid by June 16th, 2023. Because there's been a dismissal of the named party, this is gonna be entered as an all occupants judgment, where all occupants must make a payment by must make that 1950 payment by June 16th, or a writ of eviction can issue, what is that? On the 20th. Juneteenth is a Monday, Father's Day is the day before, so the next business day will be June 20th. So,
Okay.
Parties agree, we don't need your consent because technically it's an all occupants judgment, so they're gonna be signing as all occupants, but you have the terms of the agreement, and as long as that's paid by anybody for that address.
Okay.
Satisfied.
I understand.
Okay, all right, great.
Thank you so
All right.
much.
Moving on.
You all have a great day.
Thank you.
You all.
Now, how do I-
All right. If anybody has anything ready, I'll call it, but if not, I will take a quick break.
Your Honor,
Attorney Braun and I are prepared to proceed.
Okay.
This is for the 10917 Roxbury, ending in 6536. Thank you.
Who just said that? Attorney Spaniolo?
Yes, Your Honor.
Okay, hold on 1 second. Mr. Maxwell.
Oh, no problem.
You're on cue, you're on deck. Let's see. Is Cheryl Foster here? Is Cheryl Foster ready? Put it like that. I think she's here. Alfonso Johnson. Let's do Alfonso Johnson and then I'll circle back. And I'll call your case after that, Mr. Spaniolo. Calling case number 2334-7473. ID C versus Alfonso Johnson and all occupants.
good morning, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff. Your Honor, I would ask that a default judgment be entered today. Rent to retain $355 plus 160 costs totaling $515 to be paid by 6/9.
All right. Could you give me that amount one more time?
Total due or the breakdown?
Total due.
515.
All right. And that's due. Default judgment is granted. It's non-payment. Parties can redeem for $515 by June 9th, 2023. Writ of eviction may issue. Right. So that's
Your Honor, there's also Marcus Washington. I don't know if anyone checked in on that. 7472.
747. I don't have that one on my docket. That just yeah, but let's see. And did you do Tevin Bass?
That is one of my cases. We haven't called it yet, Your Honor.
Okay. See, he was here extremely early. Well, not extremely early, but I remember him from the start of the docket. I don't see him in here, but in any case, let's try to track down, what's the case number that you were looking for? And then Attorney Spaniolo, I'm gonna call your case.
Your Honor, actually, I apologize. That case I was referring to was already dismissed and it wasn't even in front of this court.
Okay, all right, well. No problem. Mr. Spaniolo. And we'll take a quick bathroom break. All right, calling case number 23346536, Evernest LLC versus All Occupants.
Good morning, Your Honor. Attorney Paul Spaniello, P72366 on behalf of the plaintiff.
All right.
Morning, Your Honor. Connor Brown, P79949 on behalf of the defendants.
Thank you, Mr. Brown. And may I have the defendant's appearance? Is that Mr. Pickett?
That is Mr. Pickett, who I'm not seeing now in the gallery.
He's here.
Oh, there is. Okay.
Can you state your name, Mr. Pickett?
My name is Philip Pickett, Philip James Pickett.
All right, thank you, Mr. Pickett. Okay, this matter is bounced around a few dates, and were we able to work out a resolution today?
Your Honor, just to give you some context, we were here back on May 16th. I think you asked the court ordered or asked the Ms. McAfee to provide a deed to the court. I'm not entirely sure if it got to you, but I've looked at it, and I also took the liberty of providing the court faxed over about, I think it was like 7-8 days ago, a title search, a lawsuit concerning this grantor and this same process server and other deeds that fit kind of like, well, not kind of like this deed. It looked exactly like it. Different dates signed on it from when the notary witnessed it. Now, I've shared that with Attorney Brown today. I didn't previously, admittedly, because I didn't know if he was going to be the attorney of record. He's advising me today he is, so I shared those in a breakout room. And we're asking the court to consider to give us some, I guess, some time to attempt to work this out more meaningfully. Either ideally 2 months, either via a continuance, stay, whatever pleases the court, but ideally a 2-month window, Judge.
Okay, is this going to circuit court in the meantime?
Well, I don't even know if it's necessary. But if it does, yeah, I mean, in the meantime, we're gonna in the meantime, that very well may have to happen, but I don't know. Mr. Brown and I are going to maybe try to work out something in the background with his client, Mr. Pickett, and Mr. Pickett's niece, Miss McAfee. So, but if that doesn't happen, yes, we will be filing the slander title action and likely making a referral to the Wayne County Prosecutor's Office.
So this is really an adjournment to get Mr. Pickett and Ms. McAfee in whatever position, assuming that this warranty deed that's presented is valid. But a termination on the deeds shouldn't take 2 months. So I'm okay with pushing this down the road, but I really don't know why, other than for reasonable purposes to make sure somebody else isn't displaced.
Well, we provided the warranty deed. Miss McAfee provided a quick claim deed, which I don't know. It doesn't sound like it made it to your file, but her deed, Judge, in my search of Wayne County, is I guess what we would call a wild deed. That grantor, there's no one in there. They're nowhere in the chain whatsoever. Their date that they signed the deed was different than the date that the notary witnessed it, and that's on her quick claim deed. I called the notary. The notary stated to me she doesn't even remember this deed. I sent you a lawsuit from the land bank showing the land bank filing a quiet title action against this same grantor and this same notary with other sample deeds. So I don't know. I don't think a circuit court action is really necessary, but I don't know. We'll see where it goes.
It very well might be, though. Mr. Spaniello can only, I suppose, speak for himself there. I did indicate to him that a stay or an adjournment of a couple months was fine in lieu of instead of pushing for a dismissal on this because it really is a title question. If something needs to be done in circuit court, then I think that the 2 months is appropriate.
I think the 2 months is, I think I can make a determination on this today, really, if I know the documentation is over here and I want to review it. I
Well,
don't
you're,
know.
respectfully, I would just,
Tell them that we turned in documentation.
I would say that that's not a, that's not
Wait, wait,
for this court to make, that it's a determination, you know, regardless of what Attorney Spaniolo submitted to the court. You know, he could provide a mountain of evidence.
But it's logical, it's a mountain of logical evidence. Anybody can file a quit claim deed. I can deed you over the Belle right now. And
it's
does it mean that this must go to circuit court for me to make a determination? Or if something's not in the chain of title, how does it even get in the chain of title? I mean, that's pretty, like, how does something get in the chain of title if it's not in the chain of title? And I'm not making a determination today. I'm just saying, I don't see how it's possible to, I mean, I'm not gonna make the determination of title. I could just base it off of this deed is better than this deed, but I'll adjourn. I'll adjourn it. I'm not gonna stick it out for 2 months though. Just go to, let's see. June 27th?
That's fine with me, Judge. It's not a problem. And I take it that'll be in person in front of you with Mr. Attorney Brown?
Yes, yes.
Okay.
Okay, let's do 9 a.m.
9 a.m. June 27th.
Does that work?
We gotta go back to court.
Your Honor, could we do? Could we do the 28th or 29th? Would that be doable since we're in person now? I'm trying to
Yeah, June 28th, work.
I have no objection to June 28th if that helps Attorney Brown.
Oh, wait a minute. I'm sorry. My June 28th is that's in circuit court in the morning. Would the 29th be doable?
I don't have any objection to the 29th either. In the morning, please.
Okay, June 29th at 9 a.m.
Thank you.
All right.
Thank you, Attorney Brown. Have a good day.
And you as well. Thank you, Judge.
Sure. Let's just keep rolling. Let's take a break. Let's take a quick break. We'll take a 5-minute break. I see you all have some stuff ready.
You done?
We'll call it's ready shortly.
We'll be back to the breakout room real quick.
Oh, we gotta go back to the break. I can't even. There you go. I look on there sometimes. The camera.
Mr. Maxim Cole?
Your Honor, I'm present.
Okay. And Mr. Brown, you're free to leave, Mr. Brown, unless you needed something else. You're free to vacate and get out of here. Don't get in the car accident.
Thank you, Your Honor.
You're welcome. Our attorney, Maxim Cole, you have Makia Lasky. Calling case number 2334747 Country House Detroit versus Makia Lasky and all occupants.
Good morning, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff. Is this 5950, Your Honor? Or no?
It is 747. Yep.
Your Honor, that matter was dismissed by fax, and dismissal was faxed on May 16th.
Okay. The court probably signed it already. We're just behind on. So I have a high volume of documents over here. We'll be caught up, but keep an eye out on the mail. This matter is dismissed without prejudice. I think you have. Do you have one with Attorney Wood?
I don't even know who that is, Your Honor. I think there's Tevin Bass. It's 7476. I don't know whether or not he appeared.
Who represented Tevin Bass? Who spoke to Tevin Bass today?
Your Honor, Brittany Mackey with Lakeshore Legal Aid. Attorney Boyke is working with Mr. Bass, and she's currently in Judge Kennedy's courtroom.
Where is he though?
He appeared earlier.
All right. Where? Well, does she? It's neither her or like he should be here at least.
Yeah.
We shouldn't have both of them.
I can send a chat to Attorney Boyke.
Yeah, try. Okay. Yeah, just because Mr. Maximkov is here and he doesn't know. He has no idea. We were about to default Mr. Bass, but I saw he was here earlier, so. We'll wait on that one, but just kind of.
Your Honor, what about 7472, Marcus Washington?
Seven, 4, 7. My docket starts at 7476. So that's either a dismissal or not on my docket.
Your Honor, my apologies. We already went through this. My mistake.
Okay. Okay, it says it's awaiting dismissal. No problem. We're just checking.
So I guess one more question, Your Honor. I think the defendant is in your courtroom. I think the ROA may say, says that it's in Judge Kennedy's, although it's a second hearing on a case. Do you have a case 7463?
74. I do not. Should I have it? Right? Have you already gone to this hearing?
We went through a first hearing, which was in front of Judge Kennedy. I was under impression that it was transferred to you. I'm looking up on the ROA. It says it is with Judge Kennedy today at 10. I think defendant is actually in this courtroom. Ms. Boyke and I have been emailing each other, but I don't know.
The clerk must have messed up, Judge. It is in Judge Kennedy's courtroom. They were supposed to send that to us.
Okay, they were supposed to send it. This is Tevin Bass? Or is this?
No, Your Honor. It's Mejudatum Maria, I believe. Bonneview is the name of my client. Bonneview Apartments. I can give the case number if the court would like a full case number.
And this is Ms. Maria right here, correct?
I see someone that is named that in the courtroom, but
Yes.
All right, just say yes. Good morning. I mean, good afternoon. We're trying to figure.
I'm my Douglas area.
Okay, and I'm going to, it looks like you have a low connection. So I'm gonna cut your video off because it makes for a better, connection. Miss Maria, is that how you say your name? Maria?
Yes.
Okay. All right,
Yes.
good afternoon. All right, so this is what happened
Good
with your case.
afternoon.
I automatically get second hearings. I don't have any first hearings. And for some reason, the clerk didn't enter into the computer from Judge Kennedy's courtroom and send you over here. So we're not about to waste your time, the attorney's time, or your attorney's time. So it's really just a determination of whether I'm gonna hear it or she's gonna hear it. And I don't think my clerk can enter anything that hasn't been transferred. We tried it in the past just because it was all parties are here, but this may be something that needs to be heard in Judge Kennedy's courtroom, because if I make an entry in my courtroom without it being transferred, it's gonna throw something up. I've done it before because it makes sense, but from a technical standpoint, we can't do it. So how many more cases do you have over here? You want to pop in over there and see if she'll hear it?
I'm logged in, Your Honor. I'm logged in. I'm not super welcome in that courtroom, off the record.
Okay, all right, we'll get that off the record,
But maybe the attorney for Miss, I apologize for Miss Maria. Elise Boyke is the attorney who I think represents her. At least she emailed me regarding this case this morning. But again, I think we're waiting. But I think we're waiting for Miss Boyke on a couple of cases.
Yeah, Ms. Boyke's on her way. I just chatted her, Your Honor.
Okay, so we'll have some questions answered when Ms. Boyke gets here, and then whatever we can, if we can over and she can hear it, then great. I'm sure the defense doesn't mind a delay, but the date and time was set for today. So in all fairness, if we can get it heard, let's get it heard. But I can't enter something unless it's switched over. So we'll figure it out. And it looks like your 476 is with Ms. Boyke as well.
Correct.
Your Honor,
All right.
Attorney Boyke, I just heard my name. I just popped back in.
Oh, you've been the topic of discussion, Ms. Boyke.
I've heard. Good
All right, so
afternoon.
look, good morning, good afternoon. So this is what's going on. Tevin Bass, I believe, is your defendant.
Correct.
Okay, so that's fine. We'll hear that case whenever it's ready. Now, there's a case that was supposed to be sent to this courtroom with Miss Maria.
Correct, Your Honor.
It's not in the system, it's in my courtroom. It's still in Judge Kennedy's courtroom. So, I mean, I think it's supposed to go to my courtroom, but can you see if she'll hear it? Because I can't enter something in my computer. Well, my clerk can't enter it because it's not gonna make sense. So either we get the clerk to transfer it over today and enter it into the system, or we can hear that case in her courtroom. Either way, it's just one case, but that's the holdup on that matter. So
I'm not sure whatever I think is easiest.
let me ask my clerk. Let me see what my clerk says, and then.
Thank you, Your Honor. I wasn't aware. I should have realized, so I apologize for that.
No. What do you mean? It was supposed to be in here.
Okay.
So yeah, it's every other same thing. So it's not.
Judge, we don't actually.
Ms. Boyke, can we talk about that case?
I was just gonna say, I just got your email, so I was about to give you a call, but I wanted to hop over here first. So is calling best, or what would you prefer?
Yeah.
Okay, I'll give you a call in just
Or
a
you
second.
can, or if you have ability to pull me in, that's fine too.
Oh,
Let
I
me
might
see.
actually. Let me
And
see.
I'll give you co-host. All right, so both of you all should be able to.
Thank you, Your Honor. And I think hopefully we should be able, we have two cases together. We'll hopefully be able to work out.
Okay, I have to go to lunch at 12:30 to 1:30. So I just want to put that, I may catch you all after 12:30. I have to get my staff a lunch, so. See
Your
how,
Honor, just a real quick question. Cheryl Foster, case 7475, who is the attorney handling that one? Legal aid?
It's me.
oh, Attorney
To
Wood.
make some cough. Attorney Wood. Oh, you don't know me?
Okay,
Yeah.
do you want to talk,
You don't-
Ms. Wood?
I did. I was trying to place you in a breakout room. I'm also ready on another case, Your Honor, with with Joe Horka.
Okay, so let's call that one. And then we can probably process Horcus before lunch, and then I'll come back and we'll finish up with Max's call at top of the afternoon. All right, which case is that, counsel?
It is the one ending in 7071.
Calling case number 23347071, SC Ridley Consulting I versus Chantel Stanton.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Good afternoon, Your Honor. Phyllis Wood, P74800 on behalf of Ms. Stanton, who's present in the courtroom. Ms. Stanton, can you please state your name for the record?
Attorney Wood, I think she just stepped out to put her daughter on the bus. Sorry.
Okay.
I mean, we can, all right. And we can still proceed. I know she's here and we spoke to her
Yes,
earlier.
she's here.
Okay.
She's been here, Your Honor, all morning, Your Honor.
If you all want to put it on the record,
Okay, we have a conditional dismissal slated for entry in this matter. That Ms. Stanton and all occupants agree to vacate on or before July 14th, 2023. And failure to do so, and plaintiff may be able to proceed pursuant to 4B.
okay.
And Ms.
Correct, Your Honor.
Stanton has given me permission to enter that, or to sign on her behalf.
Okay. And have you advised her of what 4B means?
I have, Your Honor. She understands that she's waiving notice and that failure to vacate would constitute her notice.
All right, the court is satisfied. Please make sure you get her a copy of the conditional dismissal. And, all right, thank you for that one.
Thank you, Your Honor.
You're welcome.
Has the name Jerryon Ricks been called yet?
Hold on 1 second. 7, 7, 0. What time is your case?
It was 8:30.
Sir.
It's ending at 592, Judge.
592. 592, Lavinia Rice, Chesterfield Apartments.
No, 200 Riverfront Drive, Detroit.
592. Yep. Jerryon Ricks. Now I had you checked in. You're with Attorney Horka. And did you all go into a breakout room and speak?
No.
Did you have your hand up, Mr. Ricks?
Yeah.
It was my fault, Judge. I got logged off and then I didn't have co-host. I didn't get back to Mr. Ricks.
Okay. All right. So you got Ricks. And what is Andre Davis here? Okay, I'll let you all go into the breakout room. Todd Scott, you also have Todd Scott. So Bobby Ruffin and Jeremy West look like defaults, and you have a 1:30 docket. So let's do this. I'll call for lunch right now. You all have an opportunity to talk, and then we'll call everything else at 1:30. Mr. Murray, what do you have? Because
Placement with Darius Clark, from, I think it was set for 9.
9 o'clock.
Yes.
I believe so. And where is Mr. Clark?
He's in this, he's here now. He was with the legal aid attorney previously.
This is Darius Clark. I'm here.
All right, Mr. Clark. Were you all able to work something out?
You said what now?
At this time, there is a non-payment of rent in the amount of $9,000, and after previously speaking with Mr. Clark, he indicated that we weren't able to get to that mark or pretty close to it.
All right, calling case number 2334539 Sherry D. Anderson versus Darius Clark, Agent Clark, and all.
Good afternoon, Your Honor. James Murray, PA 5490, here on behalf of the plaintiff. This is a subsequent hearing for non-payment of rent, property address 18494 Ashton Avenue in Detroit.
All right, Mr. Clark, can you state your name for the record?
Darius Clark.
All right, and how much rent is currently owed?
There is currently $5,200 owed in rent for the months of February, March, April, and May. And there is $2,500 owed for a return check and security deposit.
Also, okay. Is your monthly rent $1,300?
Correct. And then the $130 filing fee and $75 statutory attorney fee.
All right, so court fees, that's $205. You have $5,200 in back rent, and then there was a return check for security deposit.
Correct, Your Honor.
Was that first month's rent and security deposit?
Correct.
And is that first month's rent February's rent?
January.
Okay, and it's January, so January is still owed?
Correct. January is still owed. I put that as the return check for the security deposit. But yes, January will be owed. So that would be $1,300 for January and the $1,200 security deposit, whichever is more, either or.
All right, so what's your total?
$7,700 in rent and security deposit owed, plus $130 for filing fee, and then $75 attorney fee, amounting to $7,905.
All right, Mr. Clark.
Yes.
How much time do you need to make this payment?
I was actually trying to see if all this can be dismissed because I was advised earlier that because I wasn't properly served. The only notice I had was from Mr. Murray's attorney, like his office. Like I haven't came in contact with any kind of court officer or anything like that.
Your Honor, we filed a motion for a motion for alternate service that was granted at our last court hearing. And service was effectuated by posting. Proof of service of that posting was filed with the court. So that was actually incorrect information provided. And Mr. Clark, we spoke at the last hearing.
Mr. Clark, were you at the last hearing?
Yes, I was at the last hearing.
It's a money judgment that's pled, but did you get personal service?
No, at the last hearing, Your Honor, it was a hearing to hear the motion for alternate service that was ultimately granted by service by postage, and we posted service, and I provided proof of the postage.
All right, Mr. Clark. Do you have anything to say?
Yeah, I do have something to say about the return check. I paid her with a money order, so I'm not understanding how that could possibly be returned. I gave her 2 money orders.
Yeah, and neither of the money orders were able to be cashed. They both were returned bounced.
Yeah, is it possible for a money order to bounce?
Well,
when
excuse
I
me,
have
neither the checks. I have no understanding with money orders. My understanding was the check, whatever form of payment was made, was unable to be processed.
Yeah, it was money orders.
Okay. Do you know? Did you ever check to see if you're accredited, Mr. Clark?
Oh, when I called MoneyGram and gave them the receipt number for the money order number, and they told me that the money orders were uncashed.
Okay. So did you receive a refund for those money
No,
orders?
I never inquired about a refund because I didn't know what she was gonna do as far as like cashing it, like just cashing it or trying to put it back into the bank. We never got to that point of discussing that, so I never initiated a refund.
Okay. Okay. Well, Mr. Murray, what do you want to do?
Yeah, as it stands, how Mr. Clark, his next actions after he found that the checks or money orders were uncashed is unbeknownst to me, but I can say that my client actually sent messages saying that she attempted to cash the payment that were made and they were unable to, and they were unable to be deposited. So at this time, my client has not received the $2,500 that per the lease agreement Mr. Clark was supposed to provide. So we want to proceed with the 2,500 included.
All right. Well, and how much time are you willing to give him to pay this 7905?
If I can say something, like I'd rather just move. Like if I can get to the end of June, I will be moved out.
Your Honor, with that being considered, can we do a June 21st move out date so that if Mr. Clark isn't out by that time, we can file for an eviction so my client can receive her property back prior to July also being on, because then she'll be in the 5-figure range for what she will be missing out on.
All right. Is there any objection to an all occupants judgment?
No, Your Honor.
All right. We're going to do a judgment by hearing. All occupants must vacate by June 21st, 2023, or a writ of eviction may issue. So all occupants must vacate by June 21st. Judgment will be in all occupants, Mr. Clark. So Mr. Murray is doing you a favor and removing your name as a named party. So the judgment will go on all occupants. You may be able to find another place or whatever effect the judgment has on your standing as a resident. That's one less thing to worry about. However, all occupants must vacate by June 21st, or writ can issue against all occupants. That's you, that's whoever. But any questions?
No, Your Honor, thank you.
Any questions, Mr. Clark?
No, sir.
All right, well, this concludes this matter. And you all have a great day.
All right, I'll submit the judgment to the court.
All right, thank you. And the court's gonna go to recess, and I think it's just Maxim Cove and Attorney Cox who still have cases, and I'll call them first thing in the afternoon. All right, I'll see you all back at 1:30.
Hi, this is Jerry Ricks. The attorney I'm supposed to be speaking with, is it possible if we could have a quick conversation over the mobile phone?
Mr. Ricks, can you hear me? Are you still by your phone?
Hello?
Hey, you should have a prompt on your screen to go to a breakout room to meet with Mr. Horka, the attorney for your landlord. I
Okay,
can send it again if that helps.
okay. Hit join.
Yep, hit join.
Okay.
Thank you.
It takes me, Dave. Oh, you still in the shower? All right.
All right, good afternoon, welcome back. All that good stuff. I'll make sure everyone has co-host privileges. Mr. Keenan, I want to talk to you after. Have an idea. Let me get 12 people popping in. Just let them in.
Oh, I'm in. I guess.
All right. Okay, everyone who's waiting is in. Good afternoon. We've got a few people left over from the morning docket. Between the two attorneys that were on the morning docket, there are about 10 cases. It's 10 cases this afternoon. Lakeshore Legal Aid is here for those who have a 130 case. I'm Judge Adam Sabree. Welcome back from whatever you were doing on your extended weekend. Right here as soon as possible, but I'm asking everyone to be a little patient. I'll start with the attorneys, and then the landlords who are not represented by attorneys. If you have a resolution, pop your hand up. For defendants who want to speak to Lakeshore Legal Aid, Kyle Keenan and his team is here to assist. If that's your request, please pop your hand up. Yeah. You see Joe Horka, Jerry-Ann Ricks, they had their hand up. So I'm gonna call on them because they probably have a case ready. And then once we call these cases, I'll check in. Whoever's not checked in, we'll call some names. But if you're here, you're here. Just listen up for your name. But I'm gonna call 1 or 2 cases before anyway. So just sit tight, keep your devices on mute. We can tell who most of you are by your names. Some we have a question, but we'll get to that as well. So just sit tight. And Mr. Horka, I'm ready for you right now. You ready on Rick's?
Yes, ready on Rick.
Yeah.
Calling case number 2334-7592, TEGRF Owner LLC versus Jerry-Ann Ricks and all occupants.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. And Mr. Ricks, can you state your name for the record?
Jerry-Ann Ricks.
Thank you, Mr. Ricks. Were you all able to work out some type of resolution?
Yes, for the payments, for all payments to be caught up in full by June 30th.
Okay, and what amount, this is a non-payment of rent case, how much rent is owed in total?
The amount due and owing is $5,906.20. That does include his June rent, but we're giving him until the end of June to make that full payment. I discussed with him doing a conditional dismissal, box 4B.
Box 7 as well?
Yes, please.
Okay. So box 4B means that a judgment and a writ of eviction can be issued at the same time. So if you pay this $5,906.20 by what date? The 30th, you said?
Yes, June 30.
By June 30th, this matter will be dismissed. If you fail to make that payment, a judgment and a writ of eviction can enter at the same time. And then box 7 is important too, and that means partial payment won't prevent the issuance of anything. But obviously this is a conditional dismissal, so you want to get all the way to 5910 or 5906, I'm sorry, 0.20. And this case will be dismissed if not a judgment and writ can issue.
No questions.
All right, do you give Mr. Horka permission to sign your name on this agreement?
Yes.
All right, Mr. Ricks, thank you for your patience. Thank you, Mr. Horka.
Thank you.
You are free to leave.
Thank you.
You're welcome. Take care. Is Andre Davis here? Calling case number 233475996, Go To God Property Management versus Andre Davis.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. Andre Davis. There's no Andre Davis in the breakout rooms. I didn't see him check in this morning. Counsel, are you requesting a default judgment?
Yes, please, Your Honor. Total due and owing, including court costs, $3,915.
$3,915 in total. This is a non-payment of rent case. Defendant failed to appear. Default judgment is granted for the amount of $3,915. That amount must be by June 9th or writ of eviction issued thereafter.
Thank you.
596. 569. 596. Yeah. Is Jeremy West here? Calling case number 2334757 Wellesley Crop Co. LLC versus Jeremy West.
Here, come here, sit down.
Jeremy West, are you here? Mr. West in the building. All right, we now have Mr. West here. See if he's in the breakout room. I don't believe he is. So let's check. All right, counsel, Mr. West is not present. So what would you like to do?
Judge, I didn't have this one on my list. It looks like this is actually going to be a dismissal. Yes.
This is a dismissal without prejudice. All right. Keeps coming in and out. Calling case number 2334757 Peterborough Place versus Bobby Ruffin. Bobby Ruffin here.
Horka, P75969 on behalf of the plaintiff.
Thank you. Anybody on Peterborough? All right, counsel, it doesn't appear that Bobby Ruffin is here. Are you requesting a default judgment?
Yes, I am, Your Honor.
Or is this what's the total amount?
Non-payments, total due with court costs is $1,130.
And what is the monthly rent? It's like monthly rent is $88.
Might be down to 50 now.
It's down 50. Yeah, $50. Wow. All right. Defendant failed to appear. Default judgment is granted. $1,130 must be paid by June 9th, 2023, or a writ of eviction may issue. It's 575. And Todd Scott, what's going on with Todd Scott?
I think the parties are just looking for an adjournment on that one, Your Honor.
Okay, calling case number 2334757 Silver Capital Group LLC versus Todd Scott.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Connor Brown, P79949. I spoke with Mr. Scott in a breakout room.
All right. And Mr. Scott, are you here? Oh, yeah, I see. Can you state your name?
What was that?
And can you state your full name?
Yeah, Todd Nicholas Scott.
Thank you, Mr. Scott. All right, the parties need some more time on this matter.
Yes, please. If we can just get 2 or 3 week adjournment, that's what the plaintiff would ask.
I think that would be good. Mr. Scott wanted to bring to the court's attention that there are some repair issues that he'd like to see addressed. Namely that the roof is leaking and that there's water damage, including some problems with the electrical now. So hopefully those issues can be addressed before the next hearing.
Okay, about June 20th.
That works.
Through June 20th at 9 o'clock. All right. I think that concludes your docket, Mr. Horace. Oh, no, Kamal Taylor, 7072. That's 2337072 Glenwood Apartments LLC versus Kamal Taylor.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. Kamal Taylor here. Does anyone live on Linwood in apartment 301? Council.
Under non-payment rent case, total due is $2,751. That includes court costs. I'd ask for a default.
All right, default judgment is granted, defendant fails to appear. $2,751 is the amount to redeem, and that must be paid by June 9th, 2023, or a writ of eviction may issue.
Thank you.
You're welcome. Attorney Maxim Cole. Calling case number 2334-7475. This is ID Capital LLC versus Cheryl Foster and all occupants.
Good afternoon, Your Honor. Andre Maxim, P number 77071, appearing on behalf of plaintiff.
Good afternoon, Your Honor. Phyllis Wood, P74800, appearing on behalf of Ms. Foster, who's present in the courtroom.
Foster, can you state your name for the record?
Cheryl Foster.
Thank you.
Good afternoon, Your Honor. We're asking the court for an adjournment based on a payment plan that was previously arranged between Mr. McIntosh's client and Ms. Foster. And so we're looking at July 17th, 2023. If the court has that available.
Let me check. Slip job. Dates that. One second. What day was that? July?
17th, Your Honor.
We can do. My 17th works.
Well, Ms. Woods, why don't we do the following day? I think the last payment is July 17th.
I'm
right
okay with any day after that. Do we have available?
July 18th.
The 18th, that works.
Thank you, Your Honor.
Thank you. What time?
Do 9 a.m.
9 a.m.
Okay, and you all are assuming the last payment is due on the 17th, council?
Correct, Your Honor.
Okay, I'm staying out of that agreement, but so it's likely to be a dismissal on the 18th. We'll see. But good luck, Ms. Foster. We'll be back in court July 18th if necessary.
Okay, thank you.
You're welcome. All right, Attorney Wood, thank you.
Thank you, Your Honor.
Your Honor,
What's the update on these last two? Oh, last
so
one.
I'm hoping that one of the clerks from Judge Kennedy's office actually brought in the case that was supposed to have been in front of you.
Judge brought it herself. She put it.
Okay, yep, and that seems to be, yep, this is the case.
Perfect. So it's the 7463. I'm hoping that the opposing counsel, Ms. Boyke, is present in the courtroom right now, so we can just wrap that one up.
I am, Your Honor.
Boyke is here. Okay, calling case number 2334-7463. This is Bonnie View Apartments LLC versus Majidano Maria.
Good afternoon, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff.
Elise Boyke, P84955 with Richard Legal Aid, appearing on behalf of the tenant, who I believe is still present in the courtroom. Ma'am, can you please unmute and state your full name for the record?
Majidato Maria.
And thank you, Ms. Maria. All right. Go ahead, counsel.
We have reached a resolution, Your Honor. We will be doing a conditional dismissal. I will be preparing. It is a pay or vacate date of 45 days. I believe that puts us Friday, July 14th. There is a total of $2,898, including $160 of court costs. And 4B will be marked. Additionally, my client did give me permission to sign on her.
Okay. What was the final total?
$2,898. That includes late fees, renter's insurance, and $160 of court costs.
Right, and that is to be paid by July 14th, 2023, unless you decide to vacate by July 14th, 2023. If either of those occurs, any action, if you pay or vacate, case is dismissed. If you fail to pay and or fail to vacate, a writ of eviction, a judgment or writ of eviction can enter after July. Is it July 14th or June 14th?
July 14th, Your Honor, 45 days.
Okay, yeah, that can happen after July 14th. Do you have any questions?
No, my attorney explained it all to me.
Okay, all right. Thank you, Ms. Boyke, for helping facilitate that. Mr. Maximco.
Attorney
Thank you, Your Honor.
I will prepare that. I'll send it over to you shortly. And ma'am, I will give you a call just to wrap up everything in the next couple of days, okay?
Okay, thank you.
You're free to log off.
Judge, I'm gonna find that paper. I just had it.
Thank you.
You're on vacation.
I mean, I have it.
And Ms. Boyke, we're ready on the 476 matter.
Okay. Calling case number 2334-7476, ID Capital LLC versus Tevin Base.
Good afternoon, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff.
Elise Boyke, P84955, appearing on behalf of the tenant. He was present for most of the day, Your Honor. I believe he's having some tech issues. But I believe we just wanted to request a 30-day adjournment in this case to look into some repair issues and hopefully get caught up to date with that rent.
Your Honor, that is partially correct. I am in agreement with the adjournment request. I would, however, ask that an escrow order be entered at this time.
And I will not object to that, Your Honor.
All right, let's see what the monthly rent is.
I believe
595.
that's correct, Your Honor. Yes, 595.
This escrow order is going to be a little limited, Counselor, because I can't do future rents. So we're gonna be waiting for a day.
Sorry, maybe I'm not understanding. If the matter is being adjourned, the court cannot enter an escrow order to have the defendant place the money in escrow until the next adjournment?
I can't, June rent isn't due yet, so I can't order it to be paid. Well, I can order May, yes, I can. I can order May and then June rent as well. So do you all even want to prorate May?
No, I don't need, it's fine.
Okay.
Well, we would ask that May be prorated since we only have 2 days left of May.
You're saying not to worry about it, Council?
I'm not worried about 2 days in May. That's what I'm saying.
I see.
Okay. So 595 needs to be paid. Well, I'll order that escrow needs to be paid. You want to pay it to the court or do you want to pay it to the defendant? Because the court may, you want to pay it to the plaintiff or to the court? I can order it. It's up to you all.
I don't know if you have a preference, Attorney Maxcoff, but I think we would prefer to the court directly.
I'm okay with that. That's fine.
Okay. So the court will enter escrow order where I'm gonna adjourn this for 30 days out. 30 days will put us at we do the last week of June, June 27th. June 27th, 2023 at 10 a.m. And defendant must pay. Not going to prorate May's rent, but also must pay June rent timely into the court.
Your Honor, is that possible to have a date certain by which the tenant must pay to the court?
Yeah, what day is it late?
I don't know, but let's say the 10th. Could we have the tenant pay by the 10th? Madam opposing counsel, do you oppose that?
I do not. I don't know what date is typically rent is due, but I assume it's before then, so I don't have objections to the 10th.
Okay. All right. So June rent shall be paid to the court by June 10th or by the 10th of the month in any following month.
Thank you, Your Honor, and I will prepare that order and submit it to the court.
Okay. All right. Thank you, Ms. Boyke. Thank you, Mr. Maxwell.
Thank you,
Thank you,
Attorney.
Your Honor. Have a good one.
And Attorney Maxenkopf, I will reach out to you about the repair issues and hopefully we can get this resolved before the next hearing.
Perfect. And send me that CD whenever you can. Thank you.
Thank you so much.
Thank you, Your Honor.
You're welcome. Take care.
Thank you.
Thank you. Thank you, Attorney Boyke. All right. We're in the afternoon now, officially. Lakiba Haddon. Robert Ives. How you doing? Good morning. Good afternoon.
How you doing? I'm here.
All right. Do you are you requesting legal counsel?
Yes.
Okay. I'm going to invite you into Lakeshore Legal's lobby.
All right.
Thank you for raising your hand.
All right.
So do you see that invite? Do you see
yes.
Join? Okay. Click
You
join.
did join? Okay.
Yes, sir. All right. Lakiba Haddon, are you here? Yara McMillan? Yara McMillan. Is Andre Harvey here? I see Andre Harvey here. Mr. Harvey.
Yes, sir. I'm here. Yes, sir.
Do you have an attorney?
Excuse me, I couldn't hear you.
Do you have an attorney?
No, sir.
Okay, is Attorney Wagner here? Good morning, good afternoon, Ms. Wagner.
Good,
Do you
good
know,
afternoon, Your Honor.
are your clients here?
I do
Bianca
see Miss Hope Jones in the gallery, yes.
Hope Jones, okay, have you spoke to Mr. Harvey?
No, Your Honor, I have not had a chance to speak with Mr. Harvey today.
Okay, I will, parties are here, so you all should probably have a conversation and let me know when you're ready for me to call. You want me to
Thank you, Your
invite
Honor.
you over to a breakout room? And
I believe I have co-host ability, so I should be able to move Mr. Harvey and myself into a room.
okay.
Thank you.
Mr. Harvey, you may be invited. I also gave you co-host privileges, so you can get out of there if you need to. But all right,
Okay.
just let me know. Put your hand up when you all are ready, and I'll call it. Is Jacqueline Reed here? Jacqueline Reed? All right, what about Anthony Flagg? Anthony Flagg. What about Marcelina Weathersby? Is Sarah Zunda here? Sarah Zunda? What about, good afternoon, Mr. Franklin?
I'm here. Good afternoon, Judge.
Good afternoon. Is Kevin Jones here? Is Renard Berry here? And for the landlords, for the plaintiffs and the plaintiffs' attorneys, I call default an hour after. So, Mr. Franklin, if Kevin Jones and Renard Berry don't show up, I can call this case in 26 minutes.
That's fine, Your Honor.
All right. Tawanda Hall, I'm gonna place you on mute, Mr. Frank. Tawanda Hall. Does anyone live in 19196 Westbrook? 19196 Westbrook. And last but not least, is Berlene Brown here?
Yes.
Benita?
Yes. Yes.
All right, good afternoon.
Good afternoon, Your Honor. This is Attorney Nasreen Hamoud. I represent the plaintiff in that matter.
Okay, you're representing the device name Barry, but like for hey.
Yes, Your Honor.
Okay. All right, and is Benita Sims here?
Yes.
All right, I was waiting. It's the last name, it's process of elimination. Okay, good afternoon. Ms. Sims, do you have an attorney?
No, I don't. I had one, but I didn't know how to get into the room to speak with her. I had one the last time I was here, so.
Okay, and did she say she was representing you, or it was advice only?
She said she was, if it wasn't another person, but no, I never got no one contact me.
Okay, well, they're available. Do you want to talk to them?
Yes, actually, I saw her in here, but I don't remember her name.
I can meet you in a breakout room and we'll figure out who you spoke with.
Okay.
Just hang tight. I'll send the breakout room request.
Right. As people check in or as attorneys are ready, I'll call the case. I've called everyone for the afternoon docket. So if you didn't hear your name, please let me know. Attorney Goodwin, good morning.
Good afternoon, Your Honor. This is Keith Goodwin.
Good afternoon.
Yes, there was a case. I believe this was at 10 o'clock. Unfortunately, I myself misscheduled it for 1:30 today, but it looks like it was at 10 o'clock. The case number is 2334-6527. I also am looking on the Michigan court site, and for some reason it doesn't have my appearance, but I submitted one on May 5th.
Sylvester Brown versus Quentin Brown. Yeah, I do have that. I entered a default judgment on that. Can you get, is Mr. Brown here? Is Quentin Brown here?
Your Honor, Quentin Brown is with me as well. I don't believe Sylvester Brown is.
Yeah, Sylvester Brown checked in this morning.
Correct.
Yeah, so counsel, you may have to file a motion on this one unless you can get Mr. Sylvester back before the docket's over.
I'll
Get him
call.
back,
I'll see if I can
recall
give him a call, Your Honor.
Okay,
Thank you.
no problem. All right, we're gonna sign some documents while we wait until something is ready, and then when 2:30 hits, I'll circle back on whoever hasn't appeared, and we can call some default judgments. And if you're a landlord, like Mr. Franklin, keep an eye on the, if you see someone check in, or if you see your defendant check in, just notify the court or someone, and we can get you all in the breakout room so you can have a conversation. Quentin VR. Quentin VR, seems like you can't get your audio correct because I've seen you log in several times. Please message the court if you can. I'm gonna go on mute. I'm gonna sign some documents and then not going anywhere. You all have something ready, just alert the court. Thank you.
Your Honor, I wanted to, before leaving, I wanted to ask if Mr. Brown, Quentin Brown, can enter breakout room 10 with me.
That's Quentin Brown. Bingo. Okay. Mr. Brown. I don't think his audio is set up. But maybe he can hear us. Surely got an invite.
Okay.
I just asked him to start the video just so something else will pop on the screen to see if we can get him.
Mr. Brown, can you start your video?
Or join the breakout room.
It should be breakout room 10. I believe that's the one that's available.
Yeah, it looks like you invited him as well, so should have been prompted.
Okay.
All right, let's see.
Thank you.
I guess I'm back in court. Mine's break. Is that Michael's music? Confused. They're not even. Yeah, they're gonna dismiss. So I don't want that stuff on my record.
What's that?
Yes.
Let's see, what matter, are you on the matter with Mr. Pump? With, okay, you and Ms. Mood have had an opportunity to speak, or have you spoke to your counsel? What's going on?
Yes, I did. I don't know if the landlord is here. I was going. Okay, well, I just needed like a week or so or whatever, because I'm already packed up to move. I'm just needed a little time to gather up some things and to move out, because like I said, it's not safe here. The conditions or whatever, and they put the notice to quit. It's just a lot going on, and I'd never been to court for this, so I'm a little confused. So I'm going to just do what the attorney said I should do. I'm new to this, so.
Hold on, let me stop you, Ms. Sims. Did you just talk to an attorney?
Yes.
And what did the attorney say? They'll advise you?
No, I don't. I have somebody that's speaking for me, yeah, but I think I'm gonna just dismiss it if it's okay, because this is, it's too much stress. So
I think everybody here would prefer to dismiss their case. Ms. Hamud,
could you repeat that? I'm sorry.
Yes, Your Honor.
Oh,
have you talked to Ms. Sims?
Not yet, but I would be glad to if Ms. Sims is interested in speaking to me.
yes, I am.
Okay.
Okay, perfect.
See if you all can work something out. Whatever you don't clarify, need clarification beyond Ms. Hamud, just ask me when I call your case. All right. I can't offer legal advice, but if you have any questions, make sure you ask. Okay.
Okay. Okay.
All right. Now, is Ms. Boydie representing you?
Judge, I spoke to Benita Sims, previously received advice from Phyllis Wood. Lakeshore is not representing them at this time.
Okay, okay, thanks for the clarification. I was confused, but she was in good hands, so. All right.
Okay.
All right, Ms. Sims, join that break.
Could you repeat that? I'm sorry.
It should be an invite on your screen to join the breakout room.
Okay.
You want to join that, and you'll be talking to Ms. Hamud.
Okay, thank you.
You're welcome.
Excuse me.
How you doing? Be different.
Hi. How you doing? I was sitting in the courtroom 4:33. That was on my paper since 10 a.m. So I just got the message that this was the courtroom I'm supposed to be in. Somebody just messaged me from 36th District telling me to come here.
Wow, Davita Reed.
Yes.
Yeah. All right. We entered a default judgment on this case. Let me see what the terms are, and I can at least get you the terms. And if you don't agree with the terms, you can file a motion to set it aside. But the issue is that the attorney is left. So.
Sure, what's the last three digits?
7466. Hopefully you, let's see.
That's for me.
Yeah, we're pulling.
It says pay $425 or move by June the 9th, 2023.
Okay.
I owe a balance of $265. I paid the rest. I got my receipt.
Plus 160 in court costs.
Okay.
So your total is 420. What did you say? 425.
425.
425. You have the default date of was it June 9th to pay that 425. If you think that's going to be an issue, or if you 425 by June 9th, in order to change this, you will have to file a motion and set it aside. So
what are they saying that I owe?
What you said you owe plus $160.
Okay.
Yeah, and that's the $75 statutory court costs, the $55 filing fee, I think something else, but it was recited on the record. So look, Ms. Reed.
Yes.
You technically have a judgment in your name, so I can't offer legal advice, but as some practical advice, you may want to, if you're planning on satisfying this judgment, You may want to ask the plaintiff to set it aside after you satisfy it. It's a possibility, but I'll leave that to you. And if you,
Is this eviction or what? I'm lost, I'm tired.
it's a judgment in the amount of $425. It's not an order of eviction. As long as it's paid by June 9th, then your judgment is satisfied and we're done. So.
Okay. Okay.
All right, so
you said 4 what?
425 is your magic number.
Okay.
And I just think you may want to contact them after you take care of that, because you were here and a judgment may have an effect on your record, but I don't think there's any opposition to setting it aside once you satisfy it. You're not going to be able to ask them to set it aside before you satisfy it, so just keep that in mind. So they may dismiss it once you pay it. I can't guarantee it, but I know you were here, so they may work with you on that. But 425 is what's in the computer by June 9th.
Okay, and I just pay that to them? Or I pay the...
Yeah, you pay that to them. And if you think it's a problem or something, if you're panicking, then I would suggest file a motion. But if you're able to pay that, just pay that to the landlord and your judgment be satisfied. Okay. And if you want to set it aside, just ask them to set it aside and they may do it. Let them know you were in court.
Okay, thank you.
You're welcome. Have a great day.
You too.
All right. Is Kevin Jones here? Is Kevin Jones here? And Mr. Franklin, this is why I wait for an hour. Because it looks like, let's see. Is Renard Berry here? Is Renard Berry here? All right, calling case number 2334-7620, Gregory Franklin versus Kevin Jones and Renard Berry. And Mr. Franklin, can you state your name for the record? I think you're muted, sir. Let me there you go. Mr. Franklin, did you?
Okay, is that better?
Yeah, we figured it out.
Okay, Gregory Jerome Franklin, Judge, thank you.
You are welcome. And is Kevin Jones here? Is Bernard Berry Jr. here? I see a Berry.
That's not that Barry. It's Barry Brown.
All right. Or does anyone live at 4707 Field? Or is there someone who still resides in your property at 4707 Field Street?
Yes, Judge.
All right. And are you the owner of 4707 Field?
Yes, Judge.
What is the receipt of a notice to quit? Did you have this summons and complaint served?
Yes, I did, Judge.
All right, and do you know what officer served it?
I had a gentleman, Quentin Allen Senior, served it. I called Officer Dixon from the court, and because they had left, there was no need for him to go out there.
Oh, has Kevin Jones vacated?
All of them have both of them have vacated. Yes.
All right, anybody else in the property?
I have another person in there, but he was not included in that notice to quit.
Okay, and is that person, do you want that person evicted?
No, sir. No, Judge.
All right, so I'm going to dismiss this case because our issue is really moot at this point. This is a termination of tenancy to recover possession of property, and you've recovered your possession of property.
Yes,
So,
sir.
I see no reason for you to enter a judgment and file a writ that won't be executed. All right, so I'm going to dismiss this without prejudice, Mr. Franklin, and you have a great day.
You as well, Judge. Thank you. Will I be getting any paperwork through the mail?
Yeah, we're a little behind, backed up on paperwork, but you'll receive a dismissal for this matter.
That's fine. Thank you, Judge.
So just keep an eye out. It'll come maybe in like a week or two.
That'll be fine.
Okay. All right. Have a great day. You're welcome. All right, Attorney Wagner.
Good afternoon, Your Honor. I am trying to pull Ms. Jones into a breakout room real quick so we can discuss what I spoke about with Mr. Harvey.
All right, is that Heidi Jones? I mean,
Hope Jones. I think she just.
And she hopped into the break room. Did
she did.
All right, we'll see you shortly.
Thank you.
All right, it's Robert Ives. Robert Ives.
Your Honor, Mr. Ives is still in a breakout room with Miss Wood.
Okay. Is Marcelina Weathersby here? And good afternoon, Counsel.
As to the Weathersby case, Your Honor, we've submitted a dismissal.
All right, calling case number 2334-7611, Garden View Estates 3 versus Marcelina Weathersby and all occupants.
Good afternoon, Your Honor. Robert Visconti, P61756. The plaintiff will move for dismissal of that matter.
This matter is dismissed without prejudice. Thank you.
Thank you.
Calling case number 2. Okay. Calling case number 2334-7616. This is 532 Tidalway LLC versus Sarah Zunda and all occupants.
Good afternoon, Your Honor. Robert Visconti, P61756 for the plaintiff.
All right. Is Sarah Zunda or Sarah Zunda here? Okay. And does anyone live at 9000 East Jefferson on the 22nd floor? It doesn't appear anyone is here, Counsel. You're requesting a default judgment.
Yes, Your Honor, I am. I'd ask the court for entry of a default judgment for possession. Just for the record, rent retains $3,873.57. Court costs are $163.66 for a total of $4,001.23.
400123.
Yes, Your Honor.
All right, that is the total amount to redeem this property. that amount must be paid by June 9th, 2023, or writ of eviction can issue. You're welcome.
And Your Honor, on the Ives case, he's still in with Miss Wood. We're just going to ask the court for an adjournment. We anticipate that we'll be submitting a conditional dismissal prior to the next hearing.
Okay. How much time do you need?
I would say probably 2 weeks.
Let's see, what's a good 2-week date? I think June 13th. It's a little crowded, but dismissal doesn't take long. Oh, you're not writing this file. Okay, I'll call it.
Thank you.
You're welcome. This song, okay. Calling case number 233475559, Logical PM versus Michelle Williamson, Robert Ives, and all occupants.
Good afternoon, Your Honor. Robert Visconti, P61756 for the plaintiff.
Thank you.
And Your Honor, I had an opportunity to discuss this matter with attorney Phyllis Wood. I anticipate that she's going to be filing an appearance on Mr. Ives' behalf, and we do anticipate that we will be submitting a conditional dismissal to the court. We would ask the court for approximately 2 weeks as an adjournment to allow for that to be worked out.
Our court confidence in the on this case. They will have.
Oh, and I actually see that Mr. Ives and Ms. Wood are back, Your Honor.
All right. Would you like to place your name on the record, Attorney Wood?
Phyllis Wood, P74800. On behalf of Mr. Ives, who's present in the courtroom. Mr. Ives, state your name for the record, please.
Robert Ives.
All right, Mr. Ives. Good afternoon. All right, our parties to a conditional dismissal, but aren't there yet.
That's correct, Your Honor.
Okay. Does June 13th work for the parties?
It does for me.
It does for me.
Okay, and we'll be in person. So exciting. So does 9 a.m. work?
That's fine, Your Honor.
Okay. I'll see you all in person June 13th at 9 a.m. That's the day before Flag Day, according to the calendar.
Thank you, Judge.
Thank you, Your Honor.
You're welcome. Thank you, Mr. Ives.
All right.
In and out here. Jacqueline Reed here. Jacqueline Reed. And Mr. Brown. I see you.
Yes.
Here.
Yes, still here. Oh, that's a different Brown. Sorry.
That's all right. Oh, 1 sec. Jacqueline Reed. Is Anthony Flagg here? Looks like a candidate for dismissal. Calling case number 2334756, Jacqueline Reed versus Anthony Flagg and all occupants at what's address? This is case number ending in 7586. The address attached to this property is 14506 Sussex in the city of Detroit. It doesn't appear that Jacqueline Reed is here, nor is Anthony Flagg present. Court has service. Defendant failed to appear twice. Plaintiff failed to appear once. This matter is dismissed without prejudice. Hopefully it was resolved. Shall keep hope alive. Ending in 7586. Were you able to resurrect your case, Mr. Goodwin? I see you got all parties here.
Your Honor, I was actually going to ask if I could speak to Mr. Brown, if we could put Mr. Sylvester Brown in a different breakout room to speak with him.
Yeah, you have total control. I'll put him in there.
Okay. Actually, I forgot I did, so I apologize, Your Honor.
All right. Room 15. And Ms. Sims, are you?
Yes.
Okay. You and Ms. Hamoud. Ms. Hamoud, are you ready on that? Ms. Sims?
Yes, Judge. Yes, Judge. I believe we've reached a resolution. I just need to speak to my client really quick and we'll be good to go.
All right, just pop a hand up when you're ready.
Okay, thank you so much.
You're welcome. Is Tawanda Hall here? Tawanda Hall. Does anyone reside at 19196 Westbrook? Calling case number 2-334-7624, Tawanda Hall versus occupants at 16196 Westbrook. If you are a party to this case, please state your name for the record. Check the breakout rooms. Right, there's no Tawanda Hall here, nor is there anyone at 16196 Westbrook. All right, we're going to dismiss this case without prejudice due to plaintiff's failure to appear and defendant's failure to appear, but most importantly, plaintiff's failure to appear. Hopefully this was resolved outside of the court and they just forgot to notify us.
Your Honor, you didn't put me in a breakout room with Ms. Hammond, Attorney Hammond. Very.
I'm confused as.
Oh.
I'm the client, the plaintiff for Attorney Hammond and Benita Sims, and you was gonna put us in a breakout room. Barry and with the Attorney Hammond.
She's out already. I think do you all want to go in a breakout room?
Yeah, she wanted me and her to go in a breakout room.
Oh, okay.
Attorney. Yeah, thank you.
Go on. Room 12. Room 12. Attorney Wagner.
Your Honor, I've been trying to invite Mr. Harvey back to the main room, but have not been successful in getting him out of the breakout room.
I gave him breakout privileges too.
I heard you, yeah. I can pop back in there and try to tell him again.
Oh yeah, try to pop back in. Oh yeah, here he is.
Oh, here he is.
All right, Mr. Harvey is back. We were concerned about you being stuck in the digital world, in the digital room. We're gonna come get you though. All right, Mr. Harvey, I'm gonna cut off your video because you might have some connection issues. All right, Mr. Harvey, I'm gonna cut off your video because you might have some connection issues.
Okay.
Attorney Wagner.
Yes, Your Honor. Can you hear me okay?
Yes, Your Honor. Can you hear me okay?
Yeah, thank you, Mr. Harvey. I think you have two devices on, Mr. Harvey. Can you cut one of them off?
I just turned my TV.
Are parties ready on this?
We are, Your Honor. We are not.
Parties ready on this?
We are, Your Honor. We are not.
All right, Mr. Harvey, you have two devices. Yes.
No, just one.
Are you in the same room?
No, sir. I'm in the living room and the dining room and nothing in here. I just turned off my TV.
So what do you have connected to?
Nothing else but I got my phone in here.
Are you on your phone?
No, I am not.
What are you on? It's an echo. We can't. What are you on? It's an echo. We can't. It's not. You all got it. It's gotta be something that's hooked up twice.
Your Honor, we have not reached a resolution in this case. Parties are not in agreement on a move out date, and to be honest, there are some issues with this filing. We were going to be requesting that it be set for trial, likely in person if it's going to be next week or later.
Okay, let's do it. I know your connection is bad, but if you have to chime in, Mr. Harvey, to speak, just do it. Go ahead and do it. I'm not sure if I called this case. If I didn't, it's case number 233475773. Place their appearances on the record. Someone can complain to recover possession of property.
Your Honor, Hannah Wagner with Lakeshore Legal Aid, P85530, appearing on behalf of the defendant, Ms. Hope Jones, D'Angelo Royal, and all occupants. Ms. Hope Jones is also present in the Zoom gallery, as is Mr. Royal.
Right, good morning. Is Mr. Harvey in receipt of your answer and affirmative defenses, counsel?
He is, Your Honor. He was served 2 weeks ago when it was filed.
Good. And Mr. Harvey, go ahead and unmute, even if we don't have the audio figured out. Mr. Harvey, do you plan on responding? The picture that was filed.
Do I plan on what?
Strike that. Counsel. Defense counsel wants to set this matter. Is there any objection to it?
Yes, I would like for you to go ahead with the case. I think that Ms. Jones is trying to prolong the process. So I want you to go ahead with the case. We can proceed now.
Okay, was water ever cut off? All right, Mr. Do you have a deed?
Yes, I sent it in. I brought it down personally.
Okay. And why can't we resolve?
I guess Ms. Jones or Ms. Wagner don't see eye to eye. Ms. Jones actually gave me a 30-day notice and said she will be out by April the 1st. So
Your Honor,
I turned around and gave her.
That is not true.
I turned around and gave her a 30-day notice on the 28th. So her 30 days is now up. So as you see, I actually proceeded with the actual eviction, because when I gave Ms. Jones the notice, she thought it was fake and sent mail to my home with all my personal information on there and threatening my family. As you see the evidence, it's a picture of me and my family there after I gave Ms. Jones the eviction notice. So, Ms. Jones, I want to for like 10 days vacate the premises. She has a PPO out on her. She has 3 police reports, one of them as the criminal from stealing water and sending mail and defaming my name as well. So I'm waiting on the prosecutor to actually talk to the prosecutor, because I talked to Ms. Lewis, the corporal police. So she's supposed to be getting in contact with Ms. Jones. She hasn't been answering the phone. So this has been going on since what, March the 13th.
Right. And Mr. Hunt, have you heard this matter?
Excuse me, Your Honor, I didn't hear you.
Do you plan on retaining
Do I plan on retaining?
Yes.
The last part?
Yes. An attorney. Do you plan on attorney? An attorney. Do you plan on attorney?
No.
Okay, because I'm going to set another hearing date. I'm going to set a hearing date. It's very difficult to hear. And we won't be able to
Okay, I understand.
So we're back in June.
Okay.
Your Honor, if Mr. Harvey could temporarily mute, I cannot hear you.
Your Honor, Mr. Harvey could temporarily mute. I cannot hear you.
All right, let's go back and let's go June 6th. that time?
I'm sorry, Your Honor, I am out of town the 5th and the 6th, but I can do the 7th, 8th, or 9th.
June 7th?
What
June
time, Your Honor?
7th? Let's do 1:30.
That works for me.
June 7th at 1:30. Mr. Harvey? Harvey?
Yes, sir.
Well, June 7th, let's come back, June 7th.
June 7th, let's come back at
Okay, thank you, sir.
We'll be in person.
Okay.
Excuse me. Excuse me. Can he mute? I want to say something.
Miss Jones, do you wanna hold that thought? And you and I can speak?
Yes.
Thank you.
I'll see you
All right,
later.
thank you, Your Honor. We'll see you next week.
And I'll try to track down the complete file. I have yours. I want to get his deed, and then whatever else you all bring, we can get a solution. So.
Thank you,
All
Your
right.
Honor.
You are welcome. All right. Take care, Ms. Jones. Calling case number 23347628, Berlene Brown versus Benita Sims.
Good afternoon, Your Honor. Nasreen Hammoud, P number 80522, appearing on behalf of the plaintiff.
Is Miss Benita Sims here?
Yes.
Good morning, Ms. Sims. Good afternoon.
Good afternoon, Your Honor.
All right, were parties able to work out some type of agreement?
Yes, Your Honor. Ms. Sims and I have agreed to a move-out date of June 30th, 2023, and that'll be via a judgment against all occupants.
All right. So all occupants must vacate by June 30th, 2023, or writ of can be applied for on July 3rd.
And do I get my security deposit?
Mr. Move.
Yes, Your Honor. I did explain to Ms. Sims that the security deposit comes into play once she has moved out of the property. And I did this, and it does expect my client to do a walkthrough of the property. And it's our anticipation that she will receive a return of her security deposit.
Do they know the amount? Because I don't want it to be any confusion.
Well, it'd be probably most likely based on if anything is deducted from the security deposit. So, what was it? Do you know the original amount, Ms. Sims?
Yes, it was $1,012.
Okay, so you know what to expect back, and anything less than that, I'm not speaking for her side, but you still have to do a walkthrough. So,
right.
I don't think she'll be able to tell you that right now, anyway. But this doesn't have a bearing on your security deposit in the sense where whatever I adjudicate today, you still have the security deposit and whatever is going on with your landlord to sort out. And I can't give you that answer. Mr. Mood will be more helpful than me, but that's dependent on the checkout. Okay.
Okay.
All right. So There's a move out date of June 30th, 2023. It's a removal of your name as a named party on the case, so the judgment will be entered as all occupants, where all occupants must vacate by June 30th. Any questions? Ms. Sims?
No, that's it.
Okay.
Thank you.
All right. You are welcome. You have a great day.
Okay. You too. Thank you.
Thank you, Your Honor.
Thank you, Ms. Mood. You have a good day as well.
Thank you. You too.
Thanks. Okay, Judge Parker. All right, yep, you're free to leave.
Hello? Can you hear me?
On case number 2334758, this is Fairview Manor Apartments versus Akiva Hatton and occupants at 3646 Fairview Street in the city of Detroit. This matter is dismissed without prejudice. Heard. Well, defendant and plaintiff failed to appear. Plaintiff's contact notified court. These cases were dismissals were submitted for these cases. Did you say it's
Yes.
Calling case number 2334755 LT Fisher 2015 Acquisition LLC versus Tiara McMillan. This matter is dismissed without prejudice. Why is this case not? Please make sure that's not. Attorney Goodwin.
No, Your Honor, we're ready for the matter to be recalled.
I'm here.
Hold on 1 second. All right. Recalling case number 2334657. This is Sylvester Brown versus Quentin Brown. May I have appearances?
Good afternoon, Keith Goodwin, PA 3997 on behalf of Mr. Brown, Quentin Brown, who's also in the courtroom.
Thank you.
I'm here.
Can you state your name for the record?
Quentin Brown.
All right, and Sylvester Brown, can you state your name for the record?
Sylvester Brown.
All right. This matter was called earlier in the morning docket. Plaintiff was here, defendant failed to appear. A default judgment was entered. Let's see.
You need this voucher.
Yeah, I need this. All right, and the default judgment enter with determination of tenancy with the June 9th, 2023 move out date. So what would parties like to do?
Your Honor, I did, just to inform the court, first, I want to give my deepest apologies to the court. I misscheduled the matter. I did see that in my court doesn't have my appearance in, but I did file my appearance on May 5th. But regardless, I want to apologize to the court for my tardiness. First and foremost. Secondly, Your Honor, I'd ask for the default to be set aside under motion for default judgment be set aside. Mr. Brown himself, Quentin Brown, did try to log into court earlier. As he did have the right time, but he was having technology issues and could not get into court at that time. And again, Your Honor, I erroneously scheduled the matter for 1:30, believing it was scheduled for 1:30 as in the previous hearing. So that is my mistake, Your Honor. Additionally, in terms of a meritorious defense, I at first
I'm gonna set this aside.
Okay.
All parties here, you called on the same day. You had the wrong court date, and Mr. Quentin Brown was here in another courtroom. So let's just address this. We'll readdress it today, and we'll have it we'll have some type of resolution. Sorry. Default, and then okay. So now we're back at status quo. There's a guardian. Mr. Brown is a guardian for his mother, for their mother. You all are brothers, correct?
Yes, sir.
Okay. It's a guardian for their mother. Mr. Sylvester Brown, have you shared with Goodwin any documentation, any guardianship documents?
Yes, Your Honor.
Okay. And Attorney Goodwin, did you see any?
So, Your Honor, what he sent me was actually the property management agreement. However, I do also have records of the guardianship case it has. It does show that he is the representative. As far as the representative part, I don't believe he would be able to proceed on his own on the representative part. There's actually case law in Michigan called Schenkman versus Bragman. This is the site. I'm pulling up the site right now. This is site 261 Mich App 412, year 2004, where the court had decided that a representative, although they're a representative of the estate.
Mr. Brown, can you mute your vice, Mr. Quentin Brown? I can't mute it for some reason. Thank you.
Okay.
Yeah. All right. So what was that? What was the case again?
Schenkman versus Bragman, Michigan site 261, Mich App 412. And then the Northwestern site is Northwestern Second Edition site 682 NW2D 516. And this is in returns to the guardianship matter, where in that case,
was it Mr. Rakian who was on this before you? And I think this issue was presented, but it wasn't answered. Is that what?
No, that must have been a different case. I brought up the issues, but I didn't have the case law at the time. I didn't address the case law with the court at the time.
Okay.
And so under that case, it was a wrongful death action. However, it was still the same issue in terms of a representative being able to bring a case in on behalf of the estate. And then the court had decided that the representative couldn't bring an action in pro se on behalf of the estate because they are not the, for a few reasons. First, they are not the party in interest. The party in interest would be the owner, and in this case, that would be Sandra Brown. And since they're not the party in interest, it would have to be brought in behalf of the estate. And if you were representing the estate would need an attorney to represent them, because otherwise representing someone else would be the unauthorized practice of law, which I know plaintiff does not mean to do here, obviously, but that was what the state of the law is in regards to guardianship. In terms of the, I did also receive a property management agreement from the plaintiff, and the only issue I see with it, however, is that it looks like it was signed. To my eyes, it appears that it was signed twice by Sylvester Brown instead of a signature by Sylvester Brown and Sandra Brown. I don't know if the court, I was informed the court has a copy, was sent a copy as well, but I don't know if it's in front of you, Your Honor.
Oh, is that the management agreement?
Correct.
I don't have the management agreement in front of me. Okay, so Mr. Brown, Sylvester Brown, this is why I paused the case the first time. Because I had a question on whether you could represent an estate in pro per in your own name. This needs to be filed in the state's name. Is there any resolution? Are parties able to work out some resolution outside of a dismissal and refiling?
You know, Your Honor, I attempted to work out a resolution, but unfortunately we were unable to work out a resolution, which is why I had to inform the court.
Okay. All right. Mr. Brown, you're gonna have to bring this estate needs to bring this lawsuit. Because this is the estate of your mother. This is not you as a true plaintiff. So I would let you amend this, but the notice is sent out by you, Mr. Brown, which would validate things. So what would you like to do, Mr. Brown? No, unless you have an idea, I have to dismiss this case and you have to refile it under the proper party name. So is there any other, do you have any other solutions, or because if not, I'm gonna dismiss this without prejudice.
No, okay. I just realized my phone was on mute. I said I sent in the management agreement. I emailed it to the email.
The management agreement is not gonna save you. Management agreement, it helps, but the named party needs to be the estate of your mom versus you. It could have, I mean, in some sense, I would have even accepted your mother, but you're a representative. And is an estate open?
No, it's not an estate open. She's not deceased.
Okay, yeah, I didn't know if she was incapacitated or if, you know, if there was a.
Well,
Your Honor, there is a probate case open where Mr. Brown is the guardian. I can provide a case. I can provide a Wayne County probate case number.
Mr. Brown is Mr. Brown, you've taken care of everything. I mean, you're at the finish line, but the plaintiff should be your mother. The plaintiff should be
All
your
right.
mother because you don't have title on this property. So if it wasn't for the notice, I will allow you to amend, but unless parties are waiving notice, I'm going to have to dismiss this case. You have every right to refile it, but I just wish this was done. I hate to extend it out and wasted your time, but we're able to work this out and maybe parties could work something out. But I have to dismiss this case without prejudice. Mr. Brown.
Okay.
Please
Fine.
refile it with proper name. May not be a bad idea to get some legal counsel to just assist you in this, but in the meantime, if you all can work something out, work it out, but I need you to and you can you could refile today if you want to. But
okay, thank you.
All right, you're welcome.
I'll submit an order to that effect, Your Honor.
Okay. All right.
And the Quentin Brown is free to leave. I'll give him a call after court.
Thanks. All right. And Mr. Brown, Quentin Brown, you thank your attorney. And Mr. Sylvester Brown, just take another shot at it.
Hey,
Are you all
Thank you, Your
take care?
Honor. Thank you, Your Honor. And again, I apologize to the court. Thank you to the court for allowing the case to be recalled.
This is
I'll
the
see you
thing.
tomorrow.
This is the thing. If I were to give you a technical win, Mr. Brown, a motion would be filed and we will be back in court addressing the same issues in a week or two. That's just the honesty. So it's better this happened today, and thank you for reappearing. And thank you all parties. So we'll figure this case is dismissed, refile if you want to, work it out with your brother. Good luck.
Yeah, we'll work it out.
All right, take care.
Thank you, Your Honor.
Sure. And does that include the docket? I think so. All right, Madam Court Reporter.
Okay, Judge. Have a good afternoon, everyone.
You too.
All right, thanks.
Thank you, folks. Have a good afternoon.
Thank you, Brown. Have a great afternoon.
Enjoy your day, Judge.
Thank you. I know you said
You
that.
too, Your Honor.
You are welcome. I'll see you all on Friday.